Rodriguez, can you hear us?
Yes, I can. Thank you.
Thank you. Meant to mute you. Okay, on the record. On the record, in the matter of the people of the state of Michigan versus William Scho, Clifford Frost, Myra Rodriguez, Rose Brooks, Marianne Sheridan, and Kenneth Thompson. Council here.
Good morning, Lizanna Logan on behalf of the people.
Good morning, Your Honor. Kayla Prino, appearing on behalf of the people.
Good morning, Your Honor. Michael Bellotta, appearing on behalf of Mr. Rose Rook, who is in the front row and present in court.
Good morning, Your Honor. May it please the court of the Attorney Gilbert Brady on behalf of Mr. Kenneth Thompson. Mr. Thompson is welcome to my right here. Play yourself for the record, please.
Ken Thompson here this morning, Your Honor.
Good morning, Your Honor. Right Blake appearing on behalf of Ms. Rodriguez, who is appearing via Zoom.
Morning, Your Honor. Dave Coleman appearing on behalf of Mr. Choate. He is here seated right in front.
Morning, Kevin Cassidy appearing on behalf of Mr. Frost, immediately sitting behind.
Morning, Your Honor. Attorney John Freeman on behalf of Marianne Sheridan, who is behind me.
Okay. Day 4 of this set of exams, and we believe we're going to pick up with continuing the cross-examination of Agent Shock. Is that correct?
Yes, Your Honor.
Okay. And I believe, Mr. Coleman, you weren't finished with yours, so Agent Shock, you can take the stand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do, Your Honor.
You can have a seat. Counsel, was there an issue?
Typically, we could hear very well over here, but they came in and adjusted this, and I'd rather have the temperature adjusted. The fan is a little bit louder for us today. So if I raise my hand, or we may need to, because I was having a hard time hearing the court actually.
Yeah.
So
I can imagine.
This fan can be shut off. We can shut this off.
We can turn that fan off. Yep. Does that help?
It does.
Yeah,
Thank you very much.
Oh, very good. All right. Okay.
So, Your Honor, before we get going, I was waiting for the time we were doing miscellaneous things.
Yep.
So I hope this is the right
No
time.
problem.
But there's a witness named Anthony Zammit who testified, you may recall, last proceedings. He was on the witness list, I guess, originally, but maybe he's not anymore. So I didn't know that he was not going to be called, so I prepared a subpoena. I don't have any way of getting a hold of him, and I know that they do, and they've been nice enough to agree to help me, but I just like for the record to ask them, direct them to help me get this served, because I need to get him here Monday, because I don't want to time.
But we will direct the state to ensure that he served the subpoena.
Thank you very much, Judge.
No problem. Any other miscellaneous issues that we should address before?
I just want to thank the court for doing whatever it did to get the temperature.
Yeah, we had a full discussion yesterday because today's supposed to be 80. And so they thought that they supposedly set the chillers on, is what they said yesterday, not in courtroom 4. So
The indication was this was still set for heat.
yeah, agreed. And so it became a bit unbearable in the afternoon. And so hopefully we will avoid that today. So everyone can stay comfortable. Any other issues? Council, you can proceed.
Thank you, Your Honor. Mr. Shack, I think when we stopped yesterday, I'd gone through the elements of counts 2 and 3 in the forgery. We were just getting ready to start on the count 1, the conspiracy. I'd like to go there. But there are a couple questions just from yesterday I want to clarify. Regarding your search warrant for the donors for Mr. Choate's, well, not his, but for the GoSendMe account on his behalf. You said you had done a search warrant, correct?
Yes, sir.
And did that search warrant request all the routing numbers for the donors?
I believe it did, yes.
Okay. So,
well, for the subscriber's account.
Right, for the whoever came into that GoSendMe and gave money, you wanted the routing numbers of those people, right?
Yes, the routing numbers for the subscribers.
Okay. Were you able to get that?
No, sir.
Okay. And You said yesterday that you had no contact with federal investigators, right? The FBI or any investigators.
No, I did say that
I just heard that, sorry.
Agent Stupar from NARA, it's my understanding he's a federal investigator. I had reached out to him to get any information that I could about their investigation and asked him for a contact for the FBI.
Okay. Oh, that's right. So it was the FBI you'd never
Yes,
connected with.
yes, they didn't
Gotcha.
respond to my request.
Okay. And you heard Mr. Renner yesterday testify that he was visited at his home by an FBI agent and an investigator from the archives office, I believe.
Yes, sir.
Okay. And he mentioned that they had taken notes during the meeting that he had with them, right?
Yes, sir.
Okay. Did you ever see those notes, or were you aware that such notes might have existed?
To answer your first question.
I'm sorry, that was two questions.
That's okay. To answer your first question, I did not see the FBI notes.
Okay. But you were aware of the notes because Mr. Renner reported that, right? To you.
Yes.
Okay.
Through the interview.
Through the interview, right?
Yes, sir.
Right. Okay. So then did you follow up and request those notes from the FBI?
No, I did not. It was made clear to me that so going back to my first conversation that I had, it was made clear to me that they're not in a position to share information about their investigation.
Oh, okay. So they'd indicated to you they wouldn't cooperate with you, FBI. They would not cooperate to provide you anything from their investigation.
I don't know if I use the term cooperate. They just
Okay.
made it known to me that they weren't going to share their reports or information about their investigation.
Okay, fair enough. Thanks. And Mr. Renner yesterday, I think, made it pretty clear in his testimony what he understood the purpose of the meeting on December 14th to be. Would you agree with that?
Yes.
And one of the things he said was he understood that they were an alternate slate of electors, correct?
Yes.
Okay. So again, that would have been evidence that you would have had that would have worked against your statement before saying everything that you had discovered and evidence all supported guilt. That would be evidence that did not support guilt, correct?
Specifically for Mr. Renner, yes.
Okay. Well, he said that was stated in the meeting to all the electors. So why wouldn't that apply to all the electors?
Mr. Renner let us know what and how he interpreted that information.
Well, that's a pretty specific statement, that an alternate slate of electors. And in fact, you do put it in your affidavit in another that Mr. Flynn said that at the meeting. So you know that was said to all of the electors, right? I mean, you put it in your affidavit.
I don't understand the question.
Well, you just said you're trying to limit Mr. Renner's testimony that he heard that they were an alternate slate to just him. But in your affidavit on paragraph 35, you acknowledge Sean Flynn stood up and said to everybody there, you're an alternate slate of electors, right?
If it's in my affidavit, yes, that's what I said.
Do you need to look at your affidavit in order to refresh your memory?
That would be fine, but just let me finish for a moment. So
Okay.
again, that's Mr. Renner speaking. I don't have your client, Mr. Choate, telling me the same thing.
Okay. Is it your position that Mr. Choate did not hear the statement then of that they were there as an alternate slate of electors? Is that your position?
It is my belief that the information provided in my affidavit was true and accurate.
Okay.
Objection, Your Honor, this is not responsive to the question.
I'm going to follow up.
Yeah.
That's okay.
Yes, so if you want to
Yeah,
have me
let me
review
read
it,
you.
then I'll.
Yeah, let me read
Yeah.
you from paragraph 35 of your affidavit,
I withdraw the objection.
of your sworn affidavit. You said, quote, Trump campaign aide Sean Flynn spoke to the Republican candidate for electors. You got that phrase in quotes?
Yeah.
Republican candidate for electors. At the Republican headquarters in Lansing about an, quote, alternate slate of electors, right? You
Yeah.
recall putting that in your
Yes.
affidavit?
Yes, sir.
So are you trying to say Sean Flynn didn't tell all the electors that were there that they were an alternate slate?
No.
Okay, so he did tell them that, right?
Yes.
Okay. So when Mr. Renner says he heard the same thing, that we were an alternate slate of electors, why would you try to limit it to just Mr. Renner when you know everybody was told that?
Because as Mr. Renner had indicated, there were people arriving at different times of the meeting. Mr. Renner had also indicated that he appeared to be the last one there, called last one there.
And he said all the other electors were there. He saw them. He testified to that, right?
Yes, I believe he did.
Okay, so that's not an answer to my question. So why would you, are you trying to claim Mr. Choate never heard that statement, that he was an alternate slate, that he was part of the alternate slate?
No, I'm not trying to claim that.
Okay. Why did you not include in your affidavit what Mr. Renner said about the alternate slate and the purpose for the meeting? And he went into, I'm not going to go into everything he said, but he gave other reasons for what he thought he was doing. Why was that not included in your affidavit?
Because that was after the fact. I learned that after the fact. So
Okay, thank you. All right. I'd like to get back to the elements then. We were starting to talk about count one, the conspiracy to commit forgery. And it's your position that Mr. Choate was part of a conspiracy to commit forgery, correct?
yeah,
Okay. Well, let's look at the elements. And you say here in the complaint that my client did unlawfully conspire, combine, confederate, and agree together. So, and agree. So he did all of those things: unlawfully conspired, combined, confederated, and agreed. He did all those things with Maya Rodriguez, Michonne Maddox, and other persons to, and then it's the same elements for forgery, to falsely forge documents, right? You understand that that's the charge?
yes, sir.
You know, let me just go back briefly. When you say that you found out after the fact that from Mr. Renner about, you know, what he said about the purpose of the meeting, when did you find that out?
Whenever his interview was,
You don't remember offhand?
it was after July.
Okay. Did you make any effort to go back and correct your affidavit or add to it or anything like that?
No, sir.
Okay. So back to count one. Let's start with Myra Rodriguez. You claim that you have evidence that Hank Choate conspired, combined, confederated, and agreed with Maya Rodriguez to commit the crime of forgery. What evidence specifically do you have about Mr. Choate that would support that?
Again, going back to November 23rd, it was the official or the Board of Canvassers met. They certified the votes. This was not there was no recount. There was no joint meeting at the state level. These folks were not summoned through the state of Michigan to appear at the Capitol building as the statute says at 2 p.m. They decided to meet together for the most part in a private meeting where cameras, there was an effort made to conceal any cameras or any information, you know, and meet together, sign this document, proclaim it as a public document and submit it to the National Archives and submit it to the Capitol building as well. So there was more than obviously your client, Mr. Choate there. They were all in agreement that they were going to sign this document together.
Okay, so after all of that, what it comes down to is Mr. Choate signed the page 3 of Exhibit 11 that day. That's your evidence that he conspired, combined, confederated, and agreed with Maya Rodriguez.
Yes, along with all the other things
Okay.
that come together to
Okay.
bring that together.
So it's the mere fact of his signature on the signature page.
That's part of it. Not, I wouldn't
Okay,
say.
what else? What else? Then? That's what I'm trying to get down.
Oh,
to.
that's
What-
why I was just.
What evidence do you have? So his signature, what else?
I'll go over it again, I guess. Knowing that the the Board of Canvassers certified the
Okay.
vote.
Let me, I know you said all that.
Okay,
My question is very specific. Please try to answer. What evidence do you have that Hank Choate conspired, combined, confederated, or agreed with Maya Rodriguez? Okay. Not, did they know about some Board of Canvasser meeting or lawsuits that were going, or the legislature might have done something? What's that have to do with, did he conspire with Maya Rodriguez to forge a public document? So do you understand my question?
I believe I do.
Okay.
And I'm trying to add, when you keep saying what else, so I'm trying to add the additional information.
Well,
so
it's not responsive to my question. That doesn't prove a conspiracy or agreement, or that they conspired together because the Board of Canvassers met or the legislature did something. What's it got to do between Mr. Choate and Maya Rodriguez?
They were all together in the room. As Mr. Renner.
Please answer my question. What is the, I'll do this one at a time. Well, he's not answering my question, Judge. What is the Board of Canvassers meeting in November to
There's
certify?
an objection.
The witness is not being allowed to answer the question. I believe
not
counsel wants the witness to answer a specific way, and the witness is trying to give an answer, but he keeps getting interrupted. So we can't say, we can't even determine if it's non-responsive or not, because he's not being allowed to respond.
Because he keeps saying the same thing, Judge. He talks about, I'll just use the first example. The Board of Canvassers met. What does that have to do with my client conspiring with Maya Rodriguez to commit a crime?
His answer is that their meeting was part of the conspiracy, that's what I'm assuming, that's his
So
answer.
the Board of Canvassers is in on the conspiracy?
Well,
I mean, I don't get it.
If the witness will be allowed to complete his answer, we might know how that ties into the evidence.
we should allow him
All
to
right.
complete the statement.
Thank you. Go ahead.
Objection sustained.
So I'll skip over the first part. The other part that I was trying to add was that the fact that they were all gathered there together, all 16 of them. There was 2 vacancies there. There was an explanation that was offered as to why they were there, and a document that was provided.
Okay. And again, we established yesterday, my client had absolutely nothing to do with that document. He didn't create it, he didn't make it, he didn't forge it, we went through all the things, he didn't counterfeit it. So he had nothing to do with that document. Okay, so you're saying, again, what it sounds to me like what you're saying is the mere fact that my client signed it, he signed a signature page. Okay. That's evidence, that's the evidence you're relying on to say he conspired with what Maya Rodriguez.
Is that a question?
Yeah.
Oh,
Is that what you're saying?
yeah.
So it's a signature.
That's part of it, but the fact that they, like they just explained, that they met together, there was discussion about the document, all agreed to sign the document. So that together is what I'm trying to say.
And so at the meeting, you heard Mr. Renner yesterday. He was asked specifically, did you guys talk about committing a crime? Did you guys talk about how you were going to do things to, break the law or anything? There was no discussions like that. So what discussion are you talking about that was part of a conspiracy to commit a crime?
Well, the discussion itself to sign a document that is not the legitimate document.
Okay. Anything else? No.
I know.
Okay. Then let me ask you this. Count 1 says my client unlawfully conspired, not just he conspired. It's he unlawfully conspired. What did Hank Choate do illegally by attending this meeting of the electors? What was unlawful about that?
Well, the fact that it wasn't a legitimate meeting of the duly and qualified electors.
Sir, I understand you don't agree with it. You think they shouldn't have done it. I'm asking you what's unlawful, what's illegal about it. Point to anything. Is there a statute? Is there a law? Is there a court case? Something
And I
that would
believe
point to it being unlawful.
I believe the witness has provided an answer to that
He
question.
didn't answer and I'm trying to pin him down.
I believe he
You
did.
said he
answer.
did answer, you tried to.
He did not, no. I'm asking what's unlawful about, I understand they were at a meeting. He thinks the meeting was wrong. I get it. that doesn't make it unlawful. I'm asking, he's the one that brought this charge.
What about the meeting violated the law?
Right,
I agree.
exactly.
He
What's
could- he
illegal?
could be more specific.
So to be more specific and would be the fact that these individuals were not summoned by the state to appear. They were not considered as electors according to the popular vote. There was no official request or summons for them to appear at this meeting and complete this document.
So you're saying that's unlawful. So in American history, have alternate slates of electors ever been done?
Yes.
Oh, it's been done at least 6 times, right? In other states.
The exact figure, I don't recall, but it's been done, yes, more than once.
More than once. All right. So do you think then all those other people should have been prosecuted because they met and they did unlawful, they did
Objection.
alternate
relevance.
slates?
You said relevance. What's the relevance?
Well, he's saying, I asked him, what's the reason? He goes, because they met and they weren't summoned. I'm not aware, he hasn't cited any law that says that the electors have to be summoned, but whatever. I asked him then, so has it ever been done before in any other
Is
state?
there a correlation that maybe they weren't summoned in these other instances?
That, and is it, it's going to be unlawfulness issue, Judge. It's been done other times in our history. He knows that. I'm trying to pin him down on why is it unlawful, just because he doesn't agree with it.
Whether alternate states were generated, alternate slates were generated in other states at other times has no relevance to this particular incident that we're here for today.
It does when he's saying that's the reason
He's-
that it's
well,
unlawful.
He gave a broad reason that was what made it unlawful. The law that they're being charged under doesn't say that they can't come together on December 14th unless summoned. So he's got to explain what about this meeting is unlawful.
But other slates meeting in other states, which may have different laws, which are not before this court today, have no bearing on why this particular meeting was illegal. And if the court, if council wants to flesh out more about this particular meeting, that's fine, but there's no relevance to alternate slates, other states at other times under other laws.
Your Honor, on behalf of Ms. Sheridan, I would interject that it also goes to the state of mind of the electors on the 14th of December.
It goes to
But I would agree. I would agree because we're not talking about them just dealing with a Michigan issue. This is something that it teeters on the line of a federal issue. And so if he's saying that the law that violated what made this illegal, unlawful, was that they met, they weren't summoned, and they signed this document. Meeting when you're not being summoned is not unlawful. Meeting and signing a document in and of itself without someone telling you to do so is not breaking the law. So he's got to be specific as what about this meeting and this document made it unlawful and made it actionable under Michigan law, and he's not done that.
Yeah, I may have heard the testimony differently because not only did I hear the part about the meeting and not being summoned, but I believe he said that the document that they signed, they did not have authority to sign it. It wasn't a legitimate document. I'm sorry, that's how I heard the testimony.
Right, but he said it wasn't a legitimate document, and that's pretty broad too, because what does that mean? It wasn't a legitimate document, and then they didn't have the authority. They made the document, supposedly, so then how do they not have the authority to sign something they made? Whether or not I could go home and create anything I want and sign it, it doesn't mean that I'm committing an unlawful action, unless now I'm trying to use that for an unlawful purpose. He's not articulating that well on the record.
I'm not objecting to any questions about this meeting in Michigan on December 14, 2020. What I'm objecting to is what happened in other states that may be subject to different laws and different rules.
I completely agree. Are you suggesting that there's a law in the state of Michigan that's specific as to how we tender our elector?
No, what I'm objecting to is the question about whether or not those other slates that were in other states at other times under, subject to other laws, whether that testimony about whether those slates were charged is relevant here. I'm not saying, I'm not trying to limit.
I don't know if he
explanation.
asked what they charged.
He did.
Oh,
That's what I objected
No,
to. That's,
I
And Kevin-
asked, do you think they should have been charged?
and
Is what I
that's
asked.
not relevant either.
And Kevin Kiefsky on behalf of Mr. Frost, when we were actually taking a look at the very first witness, she was able to talk about an alternate certificate that was submitted back in 2012. That is in evidence. So we have previously spoken about this issue.
Yeah,
And I believe that.
your witness provided
Correct.
testimony about them receiving other alternate slates or communications and what they did with them
Correct.
and why they did them with those things. So we can now limit his understanding of
My objection.
your objection is what?
My objection is whether or not the alternate slates that were produced in other states, whether or not he can ask whether or not those, I guess, signees should have been charged. That is not
I'll
relevant
withdraw
here.
that question.
Well, yeah,
Yeah,
I don't even know how you could answer that.
That's the only thing I'm objecting
Yeah, he
to.
wouldn't, he would, that specific, I thought you said the line of questioning as to the
No.
other slates. I believe that the line of
No.
questioning as to other slates is relevant. I don't even see how he could answer whether or not they should be charged because he's not seeing these other alternate slates.
I'll withdraw.
Yeah, that was my
Yeah.
objection. I'm sorry.
So that's sustained.
Thank you.
Thanks. I'll withdraw. So let me
That's the
ask,
scenic route, Judge. I've heard you say that.
Sometimes we have to go the scenic route.
so Mr. Shock, let me ask you this. In all those other situations, including the one in 2012 that we heard about earlier, we all know about the Hawaii one in 1960. We know there's some back in the 1800s. There's plenty of times that this has happened. Have you ever heard in any of those other situations where alternate electors did an alternate slate, that any of them got prosecuted for holding a meeting to do that? Are you aware of anybody getting prosecuted for that?
Yes,
Who?
just recently, within the past year, Arizona has,
Okay.
has brought charges.
Which was after this case, right?
Georgia, yes.
Okay, let me rephrase my
so-
question. Prior
Well,
to
Your
this
Honor,
case-
I would, the question was asked and the witness is answering. I would have asked that he at least be afforded the courtesy to finish his answer.
So we're gonna allow him to finish and then you can ask your follow-up.
Fine, thank you, Judge.
You can continue, Agent Chop.
Nevada, Georgia, I think there was 4, 5 states. Now,
Okay, and they've all charged after this case was charged, right?
yes.
Okay, so prior to this case being charged,
Oh,
were you aware of anybody in the prior instances where alternate slates of electors, they met to do that, where any of them got prosecuted for that?
I'm not aware.
Are you aware of any in the prior instances of electors meetings where they signed saying they were alternate slates of electors? Or just the other party's electors? Any of those people ever get prosecuted?
I'm not aware.
Okay. You're not aware of any specific law that says anything to criminalize the electoral process for either party in nominating or handling their electors, right? Are you aware of any statute that criminalizes that process specifically?
I don't understand your question.
Well, you brought the AG's office and you have supported 8 counts here. Forgery, election law forgery, and uttering and publishing. You would agree, those have absolutely nothing to do on their face with electoral representatives for either party, right? You have to read into these statutes what you're trying to do here.
I don't understand what your question is.
Is there a specific statute that you're aware of that makes it illegal for either party, their electoral representatives, to get together and prepare a slate for the electoral process, to cast their votes as electors? Are you aware of any statute that regulates that or criminalizes that if they do it wrong?
That is specific to the party's meeting?
Right, I'm talking about the meeting, to the electors
No,
meeting to
no.
do that. Are you aware of any crime on the books for that?
No, I said,
Okay. And are you aware of any crime on the books that for electors to get together at a meeting to sign a document is a crime? Are you aware of any specific statute in Michigan that makes that a crime?
could you repeat that one more time? I
Sure.
just want to make sure.
Are you aware of any specific criminal statute in Michigan that makes it a crime for electors to get together and meet and sign a document?
Sign any document? No.
Okay. Or to sign a document dealing with their role as electors? Any crime, any statute that makes that a crime?
Could you clarify that for me, please?
Well, I think it's pretty straightforward, and it's yes or no.
I
If you've
understand
got a
it's yes or no.
statute that says it's a crime for an elector to come to a meeting and sign a document dealing with his or her status as an elector, I'd like to know what criminal statute you're referring to.
No,
There is no statute, right? Is that correct?
yes.
Okay, thank you. So, if Mr. Cho, there's no law that says to sign, again, the two reasons you've given, signature on the page, gathered together. You just acknowledged there's nothing unlawful about that as electors under the law. How is it possible for Mr. Cho to have committed unlawfully, an unlawful conspiracy with Myra Rodriguez?
I'll walk through it again. The 2020 certificate of votes is a public document.
Okay, we'll go through it point by point. How is it a public document? How is that certificate of vote that was signed at the meeting on December 14th by the Republicans? How is that a public document?
It's been filed with the National Archives, who has maintained it, published it as a public document.
Let me stop there. That's your definition of a public document?
No,
Because he's asking you, how does that become, how is that a public document? So this would mean, I need you to explain to me your understanding of what a public document is and how this is a public document.
So my understanding by statute, the certificate of votes, certificate of ascertainment is a public document. And how this became a public document was it was filed and published and maintained by, like I said, the National Archives, the Senate, and the Secretary of State, the Michigan Secretary of State.
Okay, well, let me question you on that, because that's not my understanding. We all heard Ms. Vincent testify earlier this week. Nothing was filed. She said, I got a letter. I got correspondence. That's what she called it. Correspondence. Right? You recall that testimony from Ms. Vincent?
Yeah.
Okay. So if I send a letter to the Secretary of State, or I send a letter to the Senate Vice President's office, the President of the Senate's office, that makes it a public record because I sent them a letter?
If they hold that letter and it's subject to Freedom of Information Act, then yes, I would consider that a public document.
Okay. That's your definition. When was anything filed or sent to the Secretary of State by anybody involved in this case of that document we're talking about, the certificate of vote of the electors? When was that sent directly to the Secretary of State?
I believe it was sometime in January of, I don't have the exact date, January of 2021.
And you told us who sent it, right? The National Archives sent it to them, right?
Yes.
Okay, so you're saying the National Archives filed a public document with our Secretary of State, the certificate? Is that what your testimony is? Seriously?
Yes, I'm telling you that that's what happened.
Well, you know, sir, my understanding of, I mean, maybe you can educate me here. but forgery cases, okay, when you're talking in general about them, usually it's like somebody forges a deed, they forge the document, they forge a check, they forge a stock certificate. There's some kind of document that's being altered, changed. They're trying to pass it off as real when it's not real. Okay. What you're talking about has nothing to do with anything like that. That's why I'm struggling with this. Can you explain how it's a forgery of a public document to do the certificate of vote that was done?
So the original certificate of votes, it was altered to this document. So to pass it off as a certificate of vote.
That's your answer?
Yes, sir.
Okay. Thank you. So again, just so I'm clear, the only two things that you're claiming support your assertion that Hank Cho conspired with Maya Rodriguez is he went to this meeting on December 14th and signed the document, the certificate of vote. That's it.
To answer your question, yes.
Okay. Do you have any evidence that Hank Cho talked with Maya Rodriguez at the meeting or at any time to discuss his signing the document?
No.
Do you have any evidence that my client at any time talked with Maya Rodriguez regarding coming to the meeting on December 14th?
No.
So my client did not conspire with Maya Rodriguez then, because he didn't talk to her about his signature on it, and he didn't talk with her about coming to the meeting, right?
He didn't talk to, I don't have any evidence to show that he talked to Maya Rodriguez.
Okay. Now, I don't want to go through the whole thing again here, but Mishan Maddock, the charge here says my client conspired, combined, confederated, and agreed with Mishan Maddock. Would your answers be the same to all my questions regarding Mishan Maddock and Hank Cho?
It's my understanding, as Mr. Renner testified yesterday, that Maya Rodriguez and Mrs. Burden are the ones that talked to them. So to clarify a bit, when you say your client talked to
No, I'm
Maya,
sorry, I'm object because I think the witness has misstated the testimony from yesterday, which is there were three people that were talking to them. Except that the witness meant to say there were only two. I just want to correct that.
Thank you.
And again, Your Honor, I would add, this is not responsive to my question. My question is, he's answered all this stuff now. What were the reasons why there was a conspiracy between Ms. Rodriguez and my client? And he gave the two reasons. I've gone through all of this. I don't want to have to do it all over again. I'm just simply asking as to Mishan Maddock. I'm not asking him who else talked or who else did anything. As to Mishan Maddock, which is who they're claiming my client conspired with, would his answers be the same for Mishan Maddock as it was for Myra Rodriguez?
no.
Okay, what would be different?
I had information from the GOP workers that Mishan Maddock also talked to the crowd that was down.
Okay, again, my question was, do you have any evidence that Mishan Maddock talked directly to Hank Cho?
He was down there at the time. So yes.
Just Hank Cho, not as part of the crowd.
Oh, okay.
That she
You're
talked
clarifying.
with.
No, I
Hank
don't.
Cho. Okay,
You're trying to say a one-on-one conversation.
right,
Okay, I misunderstood you. So
Okay.
to clarify, no.
all right. So you're saying because the electors, just so I'm clear here, we're at a meeting and they're told, you're an alternate slate of electors. There are other things that are going on, legislature might do, whatever, everything they were being told. Okay, and as Mr. Renner testified, the purpose of the meeting, that's what they're being told. That all those electors then knew they were conspiring with Ms. Bearden, Ms. Rodriguez, Ms. Maddock to commit a crime. Is that really what you're arguing here?
That's what I've said in my statements, yes.
And that's what I'm asking is, what evidence do you have to refute what the real purpose of the meeting was that you heard Mr. Renner say yesterday? What evidence do you have to refute that my client didn't think he was an alternate elector?
Because the document doesn't say he's an alternate elector. It doesn't say that there's no contingent language in the document.
Well, the other document that you keep, ignoring does say that, doesn't it? In fact, at least it's implied in it.
But that document's not signed by the 16 individuals.
But it was there that day, wasn't it?
Can I ask that we use exhibit numbers or exhibit letters for the purposes of the record?
Especially since I don't have any of those exhibits here, I have to go back and.
I'll be fine with that.
It's defense exhibit A, I can tell you that.
Yeah,
But yes,
yeah, you got a copy
Yeah.
here, but. Sorry, Your Honor, too many papers here. Yep, defense exhibit A. Can you hand it to the witness?
Yeah. Your Honor, may I reach?
Yes,
You see exhibit A, you've acknowledged this before,
yes, sir.
and this has been admitted.
Yes, sir.
Okay, and this is signed by Kathy Bearden, right?
Yes, sir.
Oh, that'd be fine. Yeah, no problem. And this was a document entitled Recognition of Presidential Electors Designated for Donald Trump and Michael Pence, right?
Yes.
Okay. And what was your understanding of this? Was this signed on December 14th? It was by Kathy Bearden.
That's what it says on the document.
Right. So at the same meeting, at the same time, Kathy Bearden signed this in front of a notary. And in fact, the notarization on page 2 says December 14th, 2020, doesn't it?
Yes.
Okay. So this was done at the same time, at the meeting, right?
I don't have any information to show that all the people were there. I have information to show that Troy Hudson handed the document off to Kathy Bearden.
Okay,
And I have very limited information about that.
all right. And you see the third paragraph of that document exhibit A? Doesn't it say that all have affirmed as required by Michigan's faithful electors provision, and it cites a statute, right?
Yes.
Okay, so does that tell you they thought they were acting lawfully? All have affirmed. Who's the all? Who do you think Kathy Bearden's talking about?
That would cause some speculation.
You don't think it's all the electors who were there that day at the meeting on December 14th? That they've affirmed what they were doing?
No. Well, let me.
Your Honor, I would agree with the witness that that does call for speculation.
Look, Your Honor.
that. This document that says we're at 16 presidential electors.
Yeah.
It starts off identifying what all is. Is that what's gonna cause speculation?
I tried to interject, Your Honor.
Thank you.
So I tried
If he
to.
needs time to read the whole document, we'll give him time.
I tried to interject as I went back up and looked at the 16. I was going to say yes. Initially, when I said yes, it calls for speculation. I looked back up and reviewed the 16.
No problem. Thank you, Agent John.
Yeah.
All right. So this document at the meeting, whenever it was signed, Kathy Bearden signed it the same day. It references all the electors, right?
Yeah.
And it says all of them have affirmed as required by, and it lists the specific statute, right?
Yes.
Okay, you don't take that to be evidence to show their intent that they thought what they were doing was lawful
For this specific document. Yeah.
for what they did. They say here, we've all affirmed we're electors for Donald Trump and Mike Pence, and we're doing this today following the statute. Whether they're right or not is irrelevant. They thought they were doing it lawfully, didn't they?
For this particular document, yes.
And for all the electors, right? For all the electors, yes.
No, because the other document doesn't say that.
So if you have two documents together, you're saying, well, this document doesn't say, seriously, that's your answer?
We don't have two documents together. I don't have anything to show that these two documents were presented together.
Okay. Go on, sir. Do you see what it says right after they quote the statement or the statute? I'm sorry. It says the electors thought they were following the statute. They would cast their vote for Donald Trump as president and Mike Pence as vice president, right?
Yes, that's what.
Okay. Does would sound like we are casting our vote for Donald Trump and Mike Pence?
No, it sounds like we would.
Yeah, something in the future, right? They would do it.
Yes.
How come you didn't include this in your affidavit?
This wasn't completed when I received this document. So let me finish. I didn't come into this document as a signed document. The document that was originally provided to me was blank. So I had no information that somebody filled it out.
Once you found out,
It's offense A.
Thank you.
Exhibit A. So once you did find out, did you go back and correct the record then and correct the information? Because this is evidence of their intent, isn't it?
For this document, yes.
Yeah, for the intent of all the electors, right? This is evidence of the electors' intent.
For this document, yes.
No, for their intent at the meeting. That's what this document proves, right?
For this document, yes.
Okay.
I have a quick question and hate to interject.
Oh, go ahead.
What, you say you didn't receive, you have no evidence to show that this was sitting with the other document, correct?
Yes, Your Honor. This document was provided to me by, I think it was Troy Hudson's attorney, Eric Doster. The document was blank.
Okay,
And so he had indicated to me that he had provided it to Kathy Burden. That was it. Miss Laura Cox said she had no recollection of where the document went. I think she made a statement that it was put in a filing cabinet somewhere, and that was the end of it. So I didn't have any signature, notary, or anything like
so
that.
you never, prior to this exam, or you never seen the signed copy of this, is what you're saying?
I did with the previous.
Well, prior to any exam, not just this one, the one before, prior to an examination, had you seen a signed copy?
No, there was an attorney proffer just before that exam, the first exam, and the attorney showed us a copy of it, didn't allow us to keep a copy of it or anything and examine it, and then that was it. I didn't see it beyond that.
Okay, and the information that was forwarded from the National Archives, it didn't include this?
No, ma'am.
Okay, you can continue.
Thank you. When you talk about constantly about all of the evidence, you know, global evidence that you have, you never talk about this, do you? This exhibit A.
I didn't say that. When I refer to all the evidence, I don't specifically lay out all the evidence.
Okay.
So, but we're talking about it now, certainly.
Okay, so this is one more piece of evidence that you have as to the intent of the electors that day at the meeting on the 14th of December, right?
Yes, sir.
And this refutes your claim that they knew what they were doing and that they knew they were committing a crime. This refutes that, doesn't it?
No,
No, why not?
because there's another document that was signed. So it's not just this document. This document,
I'm not
it's
asking-
like,
Sorry, go ahead.
no, you go ahead.
All right, I'm not gonna argue. All right, I understand that's your position.
Yeah.
I understand that's your position. So when you said all the evidence supports guilt, we now have this document, which clearly exhibit A, which clearly does not support guilt, right?
No.
Is that correct?
Yeah, I'm sorry.
Yeah, that's correct, right?
Yes.
Okay, and we have the evidence from the testimony of Mr. Renner and others regarding what happened at the meeting. We have the emails from Ms. Sean Maddock and Ms. Facinello. We have the other document. But all of that doesn't matter, right? Because you still think they're guilty.
That's not up for me to decide if they're guilty. That's
What do
up
you mean?
to.
You
a
turned in an
jury.
affidavit saying they're guilty. What do you mean it's not up to you?
Ultimately, they're found guilty. Okay,
You say in your affidavit, these people knew and they're guilty of the crimes that are
Yeah,
alleged here.
I'd ask that the council identify the paragraph where this witness says that the defendants are guilty in his affidavit.
He says it throughout, Your Honor, in the
No,
second
No, those
paragraph.
exact
In the
words.
second paragraph, I submit this affidavit in support of my request for criminal charges. He admitted yesterday when I asked him about this, that he says in his affidavit here that he believes they're guilty of the crimes.
Oh,
I don't
yeah.
think I have to now go through. If you want to, I'll take a break. I'll be happy to go through and find the 8 or 10 places in here where
We
it
don't
says
need 8 or
that.
10. If you
May-
just find one place, that would be sufficient.
Well, this witness acknowledged that he did that, but fine. Paragraph 8, at the end. The investigation disclosed the certificate of votes and this document we're talking about. At the end, it says, the document was made and published with the intent to defraud the National Archives, President of the US Senate, and others.
With all
There's
due
no
res-
qualification
wait, no.
there.
With all due respect, Your Honor, the council says that the affidavit states that these defendants are guilty. That specific language is
No.
not in this.
No, that's
affidavit.
not what I said. I said that this witness believes they're guilty. That's what I said.
You said that he put in his affidavit that these defendants are guilty.
That he believes, okay, that he believes.
I think
they're
I think this is semantics. I don't think he
All right.
means that was verbatim, but obviously by nature of the affidavit, if you look at the conclusion, it says that he swore to this affidavit stating that the 16 Michigan residents named herein committed criminal offenses under the law. So the question was, does he believe that they were guilty? He swore to a statement saying they committed these
I'll move on.
violations. He could answer the question.
I'll- I know the court is very- All right, so Agent Shock, back to charge of conspiracy again. Wouldn't Exhibit A show you that my client and all the other electors believe they were doing something wrong? Correct? That exhibit shows that, right?
Yes, exhibit A does.
Okay, thank you. And I would ask, lastly, as far as count 1, the conspiracy to commit forgery. You say my client conspired with Myra Rodriguez, Nishan Maddock, and other persons. Who are the other persons you're talking about here?
The 16 that signed the document.
Okay, anybody else?
Those are the people that I've been able to identify.
Okay, so you're saying all 16 of the electors knew they were committing a forgery, or that they were altering or making a counterfeit public record. That's your claim. They knew it.
Yes,
Okay. Despite all this other evidence to the contrary, right?
yes,
Okay.
So let me clarify. You said, but you no longer felt that as to Renner, though. You said all 16.
right.
Okay.
Yeah, I'm sorry, Your Honor. Yeah.
Okay.
Well, let me ask, Mr. Renner was at the meeting.
Yes,
He signed the signature page, right?
yes,
Well, those are the two things you say my client did. So Mr. Renner didn't conspire, but my client did. What's the difference?
the difference is he's been able to provide his story and testify to what he heard, what he did, what he thought, those sorts of things.
You heard his test, okay. So because he came to you and made a deal, he's not part of the conspiracy. Is that what you're saying?
No, that's not what I'm saying. First of all, I don't make the deal. So, but it enabled me to learn more about his position.
What evidence do you have that Hank Cho is in any different position than James Renner in terms of what he knew, what he was told, and what he was doing that day on December 14th? What evidence do you have that my client's in any different position than Mr. Renner?
Well, the evidence against your client in the case, absent of his testimony.
So you
That's-
don't
that's
have,
the-
so you
that's
don't
the-
have any evidence then?
No, I said the evidence in the case, absence of his testimony to, like Mr. Renner.
So because he exercised his Sixth Amendment right to remain silent, he's guilty. Because Mr. Renner came and spoke to you guys, he's not guilty. Is that what I'm hearing here?
No,
Well, please explain. That's what I just heard.
I learned what Mr. Renner's intent was based on his testimony.
Right.
Okay.
And he came to you before his testimony. He made a proffer to you, right? Or to your office. I mean, he
I
talked
think
to you.
it was
folks.
after. That was after the fact.
Whatever. At some point, he came
Yeah.
to your office and talked to either you or somebody in your office, right?
Yes,
Okay. So because he chose to talk, and my client chose to exercise the Sixth Amendment right to remain silent, my client's guilty. And he's not. That's what I'm hearing here.
again, I'm not gonna say that your client is guilty. I haven't said that in my affidavit. That's up for a jury to decide that.
Oh, so now you don't think he's guilty?
I didn't say that. I said it's not up for me to decide whether he's guilty or not guilty.
Well, please answer my question. Are you saying Mr. Choate's guilty of conspiracy here because he chose to remain silent?
No.
All
I'm
right,
not
then
saying,
what,
I'm
I
not
will
saying
ask
he's,
again then, sir, what evidence do you have that my client participated with the other electors in a conspiracy to commit forgery? As it's defined in this statute?
so I'll walk through it again. On December 14th, 2020, Michigan law says that the electors shall meet in the state capitol building at 2 p.m. Or not on December 14th, but spelled out with the, I think it's the third Wednesday or second Wednesday, but anyways, on that particular year.
Let me interrupt you here. A statute's not evidence of wrongdoing by these electors. What did these electors do that causes them to have been involved in a conspiracy to commit a forgery? That's a very specific question.
The document itself is a fake document. It's a certificate of votes. It's not a legitimate document.
Why is it a
It's-
fake document? Isn't it real? Are you saying they didn't prepare the 2020 vote for
if
the
you-
Republican electors?
Look at the legitimate document. It looks different and it has been used.
Right.
according
So
to
it's
the
not a
law.
forgery, is it? Because it looks different. They weren't
That's the
forging a
exhibit
document, they
11.
created their own,
Yeah.
right?
Is that what he's talking about? I want to see the alternate slate document.
That's exhibit 11.
Exhibit
Send
11.
it to the court.
You can continue.
Thank you, Your Honor. So you're just saying because you think there's false statements in the document, that makes it fake? The document is real. There may be false statements in it, but it's not fake. How is it
I
fake?
would object to counsel testifying.
I'm asking, how is it fake? I mean, does it exist? Is there a document that says the 2020 electors for Donald Trump and Mike Pence? It says what it says, right?
It's not the legitimate document, the legitimate
not-
certificate of votes. It's
Agent Shock, do you
a,
not understand my question? There's a difference between a fake document. You know, like I create a fake check. I create a fake stock certificate. I create something else that's fake. There's a difference between that and you create a document that you just don't agree with. Don't you see the difference between those two things?
that I don't agree with. I don't understand.
Well, you keep saying it's an illegitimate document that's got false statements in it. So you don't agree with what they did. But they're not being charged because you don't agree with them. You know, if you don't agree to them and you don't like their politics, okay.
Can counsel please
know-
ask a question?
But my question is,
Question.
what in the document makes it a forgery? What makes it fake?
The fact that it says that they're duly qualified and elected, fact that it says that they met at the state capitol building at 2 p.m.
Were they at the state capitol at 2 p.m.? They
Yeah.
tried, right?
They
At
tried.
least some of them did. They
Yeah.
tried.
Yeah.
And this
But the-
document was signed before 2 p.m., wasn't it?
Yes,
Okay. And so they went and they tried. They were rebuffed. Okay, right? Isn't that what happened? The police wouldn't let him in?
Yes.
Okay. So again, sir, I'm just trying to get an answer from you. How is the document fake? The document is what it is. It's not a fake document. It's a document that you just
I
don't
would object
like.
to counsel
This
testifying.
is testimony or argument, or I should say argument.
All
Can
right,
you ask a question, please?
how is it fake? Is it because of the false state that what you view as false statements?
The false statements, it hasn't been recognized by the state. It doesn't look like the state, but it was intended for the same purpose, to serve as a slate of elector.
Sir, have you ever heard of a ladybird deed? You know what a ladybird deed is?
No, sir, I do not.
Okay, it's a deed that's done in a form and it's held by an attorney or by somebody, and it's not filed with anybody, with the register of deeds or anybody.
Objection.
So does that make that deed a
What's-
fake deed?
What's the, I was gonna say, what is the
Yeah,
relevance?
so does that make, because it's not filed, you just said it has to be filed. So if that deed's not filed, does that make it a fake deed?
I can't answer that. I don't know.
It's still a
Well,
deed, right?
I'm addressing an objection.
What's that?
What's the relevance?
Well, the relevance is, I'm trying to pin him down on what he means by fake.
I
He
believe,
keeps talking about it being a fake document. It's not a fake document. I'm trying to.
Well, that's
pin him
your
down.
argument. He said it's a fake document. And why is it a fake document?
So,
What was your testimony as to why it was a fake document?
because the document says that they're duly elected and qualified, which is not true. The document says that they and I have to refer to the exhibits
So
again. Your
Not to
Honor.
cut you off, but I'm just trying to remind myself of the gist of your response. And your concern or follow-up question is that you dispute that what he's describing as a fake document versus a document that has false statements? Is that your follow-up?
Right. My argument, Judge, and I'm trying to pin him down on this, is there's a difference between forging or.
We have to
making
ask him if
fake
there's a
documents.
difference. You can't make him believe a difference. He may not believe there's a difference.
Well, that's what I'm trying to
Yeah.
pin down.
You can't make him testify to what you want him to
I
testify,
understand.
but
Judge.
you can get some clarifying
Well,
questions.
let me
So
ask you-
I'll
yeah.
sustain your objection
Let
and
me
maybe
ask it
rephrase
this
your
way.
question.
Yeah, I'll ask it this way. Agent Shock, you think that if a document has false statements, you define that to mean it's a fake document because it has false statements.
That would be part of it, yeah.
Well, what else?
Could be the makeup of the document, the color scheme of the document, depending upon what type of document, you know, it's hard for
I'm
me to
not
make
talking
a.
hypothetically. What else from this document
Oh, from this
that
document,
makes it fake, other than you said that you think it has some false statements in it,
false statements,
What else?
the signatures.
but the signatures were real? They weren't fake signatures. They weren't forged.
I understand that the document in its complete form, you know, so that's what I'm saying.
Okay, so all I'm hearing is that because it had a few false statements on the first page, which is page 2 of Exhibit 11, that makes it a fake document.
Your Honor, I believe that's a mischaracterization of the witness's
So
answer.
he could say that's not what that's a question. So he could say, no, that's not what I said.
Okay.
But
Yes, okay, thank you. And then.
He said yes?
He said yes. Okay, so since in your opinion, there's false information or statements on the first page of the certificate of vote, that means it's forged. I'm just trying to clarify here.
Could you say that again?
You're saying that there, again, we're on this conspiracy to commit forgery.
Yeah.
Okay. You're saying because this group got together, they had a meeting, they signed this document, and the first page of the document, page 2 of Exhibit 11, had, in your opinion, some false statements. That's the crime. That's the conspiracy. That's what they're doing in forging a document. That's it, right?
That's part of it, yes.
Okay. In your mind, do you see any difference between a fake document versus a false document?
No.
Okay, so So if you had a public document and it's in the proper format and it's signed, whatever the document is, and it's signed, but it contained false information, you're saying that's the same thing as having an actual fake document?
Yes,
Okay, you don't see a difference in that?
between fake and false.
Yeah,
No, I don't.
okay. And again, the last thing here on the count one conspiracy to commit forgery. We've identified the conspiracy was among all of the 16 electors minus Mr. Renner, right?
Yes.
Okay. That they all conspired to commit this crime as you've defined it, with the intent to injure or defraud, right?
Yes.
Okay. Who was injured?
Are you talking about physically?
I don't know. You tell me. You're the one
The
that's saying
people-
that my clients broke the law here. You tell me.
Is actual injury an element?
No,
Yes. it
No.
is.
No,
With-
it's with intent.
With
So the
intent.
question should be, who do they intend to injure?
All right.
Thank you.
I'll rephrase. Who did my client and the other electors intend to injure?
The people of the state of Michigan and the people of the state of Michigan.
Okay. And the only thing they did was submit the certificate of vote and the other documents that are part of Exhibit 11 that we've been talking about in Exhibit A, right?
Yes, sir.
Okay.
I'll have a follow-up. Who do they intend to defraud?
People of the state of Michigan, Your Honor.
They, just for my clarification, this is people, I'm sorry, this is People's Exhibit 11, was sent to the federal government or it's entity in the state of Michigan?
Are you asking me?
I'm asking you,
Yeah.
who was it sent to? People's.
It was
11.
sent to the Senate, US Senate and the National Archives.
Okay,
That's what I had.
with the intent to defraud the state of
this-
Michigan?
The people of the state of Michigan. And through that, because that's the normal process where the certificate of votes would be sent to be counted.
Okay,
So as,
so it's not your position that their intent was to defraud the US government at all?
I mean, ultimately, yes, because if you're put in a position where you have two slates and it causes disruption in the electoral process, then yes, it could as well.
Your
Impact
investigation, I'm sorry, I didn't mean to cut you off. I thought you were done.
No, to impact the federal government as well.
And you don't have any evidence through your investigation that this was sent by any of the electors or their agent allegedly to a Michigan entity? My understanding is it came from.
Yes, you're right.
Okay, it came from, the Secretary of State of Michigan got it from
The National
Archives. Okay,
Yeah.
thank you. You can continue.
Okay, thank you. All right, Agent Shock, I'd like to move to counts 4 and 5, the uttering and publishing counts. And count 5, let's start there. Again, you have a copy of the counts.
I do.
I don't seem to have an extra copy. Does anybody have an extra copy of the counts?
Are you talking about the complaint?
Yeah, the complaint, yeah. Oh, Agent Shock, do you have a copy of that? The complaint?
Yes.
All right, on page 2, the backside, the second page of the felony complaint. You see count 5, uttering and publishing?
Yes.
Okay, I'm gonna ask you, what evidence do you have that Hank Cho uttered and published as true the certificate of votes? Exhibit 11, pages 2 and 3.
By signing the document. Is that your question? or
I'm
am I
asking, how
missing-
did he utter and publish? I'm asking you what evidence you have of Mr. Cho uttering and publishing as true the certificate of votes.
So by signing the document and claiming it to be the legitimate slate of electors.
Okay, and yet you acknowledged yesterday that you have no evidence that my client ever saw the first page of the certificate of vote, correct? That's what you testified yesterday.
Yes,
Okay, so how would he know? If he did, you have no evidence that he read it. All he did was sign his name on a page. What evidence do you have that he knew that he was uttering and publishing that document as true? When you have no evidence he ever saw the first page.
the statements that I've gathered in my investigation said that there was more than just that one signature page there, that there was other documents there as well. And
Well,
also,
but you're not charging him with uttering and publishing other documents. This is very clear. He uttered and published what? The certificate of votes of the 2020 electors. That's pages 2 and 3 of Exhibit 11, not other documents.
I was just trying to finish. So also with him walking over to the Capitol with the intention of serving the documents. And
How do you know he went there with the intention of serving documents? You have no evidence to that effect.
Mr. Norton is there explaining it's
Not my client, right?
I understand that. So that's, you asked me for the information that I had. And I'm trying to provide that to you.
No, I'm asking you to tell me how my client uttered and published as true the certificate of votes of the 2020 electors.
Your Honor, counsel doesn't get to dictate how the witness answers the question if he is answering the question.
I would agree.
Okay, but I'm pinning him down to, I could have been at the mall yesterday doing something. I mean, walking somewhere, that's not proof of
He sounds
uttering
like-
and publishing.
I recognize it. That sounds like argument to me, not,
All right.
you
all
can
right,
make him change his answer to align with yours.
All right, I understand. So you believe him walking to the Capitol building, uttered and published as true, the certificate of votes of the 2020 electors?
Yes, signing it and then
No,
walking.
my question was walking to the Capitol.
Oh, I'm sorry. Yes.
Okay, you felt that proves he uttered and published.
No, by signing the document
Okay,
and
again,
then
I'll come back to the signing. I asked you, you said specifically by him walking to the Capitol, that proves he's uttering and publishing the certificate of votes of the 2020 Michigan electors for the Republican Party.
maybe I'm getting too far ahead because the statute also says with the intent to defraud. So
Well,
that's where I'm tying in the.
That's a later
walking.
element. That's a later element. I'm only
the
talking
Capitol.
about the uttering and publishing.
Yes, the signature. I'm trying
Okay.
to answer your question,
Okay.
Mr. Coleman. So
All right.
forgive me.
So you would
I'm
agree
jumping
him
ahead.
walking to the Capitol does not prove he uttered and published anything, right?
Right, yes.
Okay, so the only thing that you're claiming proves he uttered or published something was his signature on a signature page.
Yes, by adopting, by signing it, you're adopting.
Oh, wait, wait, wait. How do you know he adopted it? You don't have any evidence of that. That's your assumption, isn't it?
When you sign something, you're adopting whatever you sign.
Really?
That's my belief,
Exactly. That's your assumption, right?
my belief.
Okay. And you don't have any evidence of that. You believe he meant to or no, but you don't have any evidence of it, do you?
Evidence what?
That he knew and believed that he was signing, because he didn't see the first page.
But as Mr. Renner testified, it was explained to the group what was going on, and what the purpose of the meeting was and all of that.
Exactly.
Yeah.
That they're an alternate slate.
Yes,
And that there were other things and legal challenges and legislature action, and things going on, right?
yes,
Okay, so how does that prove he uttered and published something that wasn't true? If that was his understanding.
How does what prove?
His
I don't-
signature on the page. How does that prove his mere signature on a page without any other, you have no evidence
But
that he saw the first page. You have this other evidence about what was actually said at the meeting. How does that prove he uttered and published as not as true the complete document?
by the totality of the circumstances at the meeting at that time. And I think I've already told you.
But the totality of the circumstances, sir, where they thought they were an alternate slate, that they were aware of other lawsuits
That's the
pending,
council asked the
and all of that.
question.
That's the totality of the circumstances.
Is that a question?
Yeah, so what circumstances are different than those?
That wasn't a question.
So what circumstances are different than the circumstances Mr. Renner testified?
So the fact that the document doesn't say that they were an alternate.
Okay, again, ignoring exhibit A, which did make it very clear. What they were
That's
doing.
a different document.
Well, I know, different document, don't say meaning, but you don't care about that.
Move to
You only
strike.
want to do this,
Strike it.
you only want to focus on that one document, right? The 2020 vote.
That's what we're talking about.
I'll move on. And again, I'll ask the question here. Well, let me ask you this. Do you think that walking to the Capitol by some of the electors had anything to do with the walk, with the uttering in public?
Not the other in publishing.
Okay, so it's the mere signature on the signature page by all electors that day, that is the uttering in public.
With the information that was provided at the meeting.
Okay.
Let me ask Agent Shaw a question. If the document had stated that it was an alternate slate, would that have changed your investigation at all?
Yeah,
Okay.
if it had some contingency language, like say Pennsylvania, or like this other document that Mrs. Burden had signed.
You said, say, if it said Pennsylvania?
No. If it
Oh.
had some contingent language
Oh,
like
okay. The state of Pennsylvania, they had.
yes.
Okay, but so because this didn't have any appearance of contingency language that's would steer your investigation the way it did.
Yes,
Okay.
Your Honor.
Okay, you can continue.
Thank you, Your Honor. And again, a lot of these questions I was saying from the first round with counts 1 through 3. But the claim here for uttering and publishing is that my client, Mr. Cho, published as true a false, forged, altered, or counterfeit record, instrument, or other writing. Do you see that?
Yes.
Okay, so let's go through those. What did my client do that was false? How did he utter and publish a false statement?
Signed the false document.
Okay. Of a document he didn't, as far as you know, and as the evidence shows, he didn't see the first page.
Based on the information that I received, that there was more than one page, and then they explained what they were doing. Did I?
Really? Well, sorry, who explained what they were doing? He explained the first page? You're the first person to say that. I haven't heard anybody testify to that.
I'm sorry, Mr. Coleman, you cut me off. So,
Well,
so as Mr. Renner had said, they explained.
okay. So since Mr. Renner said what he said, how would Mr. Choate know he was doing anything false? He thought legitimately he was an alternate elector, that there were challenges. How does that make anything he did false?
The fact that it doesn't say he's an alternate elector.
But he never saw that. So I'm asking you what Hank Choate did that was false.
He signed a document and was at a meeting where they convened and wanted to create a alternate slate of electors to go forward and present a slate of electors but it wasn't an alternate slate. It was, according to the document, it was the duly qualified elector.
You just said to Judge Simmons, in Pennsylvania, they put the words alternate slate, an alternate thing on their document. You just admitted, these people thought they were an alternate slate. So because it's just spoken at the meeting, it's invalid, it's illegitimate, that means it wasn't contingent? I don't understand your distinction. What's the difference?
That's what Mr. Renner said.
Well, you just testified that you accepted that they were told these things at the meeting.
I misspoke. That's what Mr. Renner said.
You said it in your affidavit, sir, paragraph 35. Mr. Flynn told them also.
Yes.
Okay,
But
so they told them that. Why is something being done verbally any different than being done in writing on a document
well,
for this purpose?
The difference is it doesn't say that on the document that they're an alternate slate.
So you ignore all the testimony and evidence that these people thought they were all alternate slate of electors. You just ignore that.
No, sir.
Well, how do you apply? How are you taking it into account? You're prosecuting them.
Take it into account.
How? I don't believe it then, obviously.
Because what the actions were was to sign the document that said that we're the duly qualified electors.
Do you have anything to explain to me the distinction between saying we're an alternate slate of electors on the written document versus we're an alternate slate of electors at the meeting when it's being introduced and everybody's talking about it and they're signing thinking they're alternate slate of electors? Can you explain to me why legally those are different?
I can't offer a legal explanation. I don't quite understand where you're going, but
Well, you seem to accept the fact that in Pennsylvania, they put it in writing on their document that says we're contingent alternate slate. Not contingent, sorry, we're an alternate slate. Here you have lots of evidence. You just heard a bunch of it yesterday, where all these electors thought they were an alternate slate. And yet you still say they had the intent to defraud, right?
Is there an objection?
Yes, that's a mischaracterization of the evidence. There's no evidence to what the defendants thought. I believe the testimony is what Mr. Renner thought, but that can't be attributed to the defendant's thoughts.
I agree. To the extent that Mr. Renner, my recollection of his testimony is that that was what they were told.
Yes.
And so we can't speak to what the other defendants thought specifically, but if Mr. Renner's testimony was believed, and obviously it was because he was granted this deal, then his position was that they were told this was to be an alternate document.
Oh, I agree that what Mr. Renner testified to. I'm just saying it cannot be attributed to the mindset of the defense.
I agree that Mr. Renner can't testify to what the others thought. He didn't even know their name. So, and he made it clear he didn't really talk to them. So he couldn't tell what they thought, but we did hear him say on more than one occasion what they were told.
Correct.
So I'll sustain that objection.
Okay, thank you, Ron. All right, as far as the element that it was false, again, you're so unclear. It's because my client signed that signature.
yes.
Okay, what about forged? Again, here we are again, with the word forged. What about that document was forged? Would your answers, let me shorten this. Would your answers be the same as they were for
Yes,
the
sir.
first round on the other
Yes.
counts? All right, thank you. And again, what evidence do you have that Mr. Choate forged the document? I think yesterday you said you don't have it, right?
He
That he
created it?
That he
Yeah,
created
yes,
it,
no.
I think. Okay. And also the altered, I just want to make sure on each of these counts. So you're not
Understood.
claiming Mr. Choate altered that document in any way, right? Is that correct? The certificate of vote
He
document.
didn't create it.
He didn't alter it.
No, well, the document,
He didn't alter it. I'm saying. Mr.
Yes,
Choate.
yes, yes, to
Okay.
answer your question, yes. I just want to make sure that I understand what you're saying.
Exactly. And again, this is just Mr. Choate.
Yeah.
And Mr. Choate did not counterfeit the document anyway, did he? Just like yesterday, you said he didn't counterfeit the document.
Yes, he did not create the document.
Okay, well, are you saying he counterfeited it in some way? What evidence do you have he counterfeited it?
Well, it's a fake document. It's not the legit,
I know that's
so I
your
don't,
position. What did he do? How did he counterfeit it? If he didn't create the document, how could he if I don't make the fake $20 bill, how did I counterfeit?
but if you're trying to,
That's not the question.
okay.
This is a specific element. He counterfeited it. If he didn't make the fake counterfeit bill or document, how did he counterfeit it?
By signing the document.
Okay,
That's your answer? Okay.
next question.
Also says that my client has to know that the instrument, the certificate of vote, he has to have the knowledge that it was false, altered, forged, or counterfeit. What evidence do you have that he knew that, not that the documents, I understand what you're saying, it's false, it's fake, it's illegitimate, I get it. What evidence do you have that Hank Choate knew that it was false, altered, forged, or counterfeit?
Again, it's not the legitimate document. It doesn't look anything like, it doesn't have any government.
Sir, that's not my question, please. What evidence do you have that he knew that it was false? I know you're going back to your question. I think it's false, it's illegitimate. That doesn't prove he knew it. What evidence do you have that he knew?
So it has no government seal. It doesn't, so that's,
Did Hank Choate see that? Does he know that? What evidence do you have he knew?
I would ask that the witness be allowed to finish his answers before the next question.
Thank you.
It's not responsive, Judge.
Well,
You
you have
don't
to
answer the
object then.
question.
You have to say objection, non-responsive, so we can address the objection.
All right,
If you just talk over him because you found it non-responsive, then that lends the prosecution to believe that you're just cutting them off.
all right, understood, Judge.
so the document's not an official state document. So to answer your question, by signing that document, it's not it doesn't make sense that you're signing a document that's not the official document. You're not, and I
Let me ask you
keep kind of
this.
going over the
Yeah,
same
let me ask you
thing.
this
So
one.
that's my belief, Mr. Coleman. So
Okay, you have no evidence that Hank Choate knew that document, 2027 vote, pages 2 and 3 of Exhibit 11. That Hank Choate knew that document was false, forged, or counterfeit. You have no evidence that he knew that, do you? That's a yes or no question. That he knew, not this generality stuff, that he knew. Do you have any evidence?
I believe that he did know.
I didn't ask your belief. What evidence
Oh,
do
I'm
you
sorry.
have that he knew
By
that it was false, altered,
by-
forged, or counterfeit?
Let me finish. By the fact that this is not a legitimate document, you have no
Did he know
reason
that?
to.
What evidence do you have
Please
that Hank
allow
Choate knew
the
that?
witness to finish his answer.
I'm
Again,
sorry,
we just-
go ahead.
We discussed how you properly object. Thank you.
So goes back to, you're signing a document that it's not, you're not called to the state capitol building at 2 p.m. You're not, there's no official seal, there's no official government process that you're involved in. So the evidence that I have is the fact that he's signing something. I know that he signed it. He tried to serve the document with others at the Capitol, not physically holding it, but walking with them with the intent to serve the document. So I'm trying to answer the best that I can.
No,
So that's the evidence, and I'm trying to lay that out for
We're
you.
trying not to answer the question, sir,
Move to strike.
because, fine, I'll withdraw. You said that umpteen times. of the overall evidence and what
Yes.
happened in general, and it's got false statements, all that. I am asking you, please, once again, what evidence do you have that Hank Choate knew any of that? What evidence do you have other than your belief?
No, the evidence is the document.
Right, which you have no evidence that he saw. You've already admitted it. You have no evidence he saw it. That's my point. So if he didn't see it, how can you attribute that document to his knowledge?
Based on the, well, one, the testimony that Mr. Renner had given, that he, that all the people in the room heard what was going on and what was being explained to them and the process and stuff like that. So that's the evidence that I'm relying on it as part of the total investigation.
Okay, so do you have any evidence that Hank Choate knew that the document in question, the 2020 vote document, that certificate was false, altered, or forged, other than this generic?
Other than
stuff
the
you already
information
talked
that
about?
I provided to you,
Well, Your Honor, I'm gonna object this asked and answered. Just because counsel doesn't like the answer doesn't mean he gets to keep asking you until he gets a different answer.
Well, no, he's refusing to answer because I keep asking, what evidence do you have about this defendant specific? And he keeps talking in generalities. He doesn't answer the question. It's a yes or no question. Do you have evidence or not that he knew?
Well,
It's that simple.
you didn't ask a yes or no question. You said what evidence?
Well, but then I came back, I said, do you have any, my last question, do you have any evidence that my client knew that that document, the 2020 certificate of votes, was false, the elements, was it false, altered, forged, or counterfeit? Do you have any evidence, it's a yes or no, that he specifically knew?
So he can answer as to whether or not his client specifically knew, or does he have evidence that he
Not
specifically
in
knew?
general, specifically, Mr. Chuck.
other than what I just said, no.
Okay, thank you. All right, we're going a while. I'm happy to keep going, but I mean.
Nope,
people
it's
need a
been an
break,
hour
I'm
and a half,
happy to do
so
it.
we'll take a break for 10 minutes.
Thank you, Judge.
Thank you. Back on the record. uh, Continue, counsel. Counsel, you ready?
Yes, I'm sorry, I was waiting for.
Oh, I see, yeah, so you can continue.
Oh, okay, I'm sorry, I didn't hear it, Judge, sorry about that. All right, Agent Shock, I want to ask you a couple of questions back to the issue of Mr. Renner. You said he came forward, talked with you, explained his thinking and all that, and then the charges were dismissed against him, right?
Yes.
Okay. And because my client exercised his constitutional right to remain silent, as well as others, we're here today, they're charged. Was there any other reason why Mr. Renner had his charges dropped and my client's charges? Other than he spoke to you and my client didn't?
I'm not aware of when charges are dismissed. I'm not in those discussions, Mr. Coleman, so I don't know.
Fair enough. Let me ask this, didn't Rose Rook come in and speak with you?
Yes,
Okay, she explained her thinking, right? Her intent, right?
yes,
And she told you she had no intent to defraud anybody, that she thought she was an alternate slate, right?
don't remember what her exact words were, but I remember the alternate slate.
Yeah, so she thought she was in the same meeting where it was said to all the electors, you're an alternate slate of electors. She told you that's what she thought, right?
Yes,
Okay, she was at that meeting. Why is she
Yeah.
still here?
Yeah, I'd ask if these statements of Ms. Brooke are being admitted for the truth of the matter asserted, or if
State
they're
of
for
mind.
effect of whose state of mind?
My clients, because he's claiming all the electors, he doesn't know their state of mind. Well, if there are other electors who came to him and said the same thing, consistent with Mr. Renner, I think that's relevant information that goes to state of mind.
Well, I'm going to object to Ms. Rook's statements post December 14th, 2022, investigator Shock being used for the state of mind of Mr. Cho, who was not party to those statements.
Well, I think it goes to credibility, not state of mind, because he testified that Renner was dismissed for a specific reason. So now he's trying to ask, well, if those same reasons apply to her, why wasn't it dismissed as to her?
But
Right.
So I think it goes to credibility.
But that's not his question, and that was not his rationale.
That was the question.
Yeah.
She said that she told you the same things, why weren't they dismissed?
And when I objected, he said he was using it for his client's state of mind. and-
I recognize that's what he said. I recognize that probably is why he was using it. I would have sustained the objection for that purpose, but for the fact that I believe it goes to credibility.
I was just gonna interject, Your Honor, yeah, from Mr. Rook, is I believe that it also goes to what counsel was doing, which was exploring the evidence that did not support his theory. I think that's what was also.
Believe counsel has
correct me if I'm
stated
wrong.
here.
No, that's
Because
correct.
he's made statements that everything I looked at pointed to guilt, essentially.
He doesn't have standing for the objection, is what you're saying? He doesn't?
Right, because it's my objection to
No.
questions of Cho.
Your Honor, I'm in the same proceeding, and this is the same record, so I am permitted to object to objectionable things.
I agree. I'm going to overrule the objection because I think it goes to credibility as to the question about about Ms. Rook. He's already reserved the right to recall him. He can ask this question himself if he wants. But as to him trying to pin down and identify why it was determined that Mr. Renner had the mindset that differed from the rest of them, but Ms. Rook didn't. I think that's a valid question, and understanding the credibility of his statement is as to why he didn't believe that Mr. Renner was guilty of the crime or committed, I should say, the crime that was alleged to have been committed. So that objection is overruled.
Thank you, Your Honor. So do you remember the question?
No, I was gonna say, could you please?
All right, Agent Shock, I don't blame you. Thank you.
Yeah.
So given that the same, or not same, similar proffer with similar information,
Yes.
admitted, was made by Ms. Rook to your office, why is she still charged and Mr. Renner is not?
I can't answer that. I don't make the decision to dismiss charges. So I
Well, you was,
can't,
okay,
I don't know.
but
I don't know.
in your opinion, did you have any objection to Mr. Renner being released as a defendant, the charges dismissed against him?
Objection, relevance to his
Well,
opinion.
Because
said,
he's
did he
the
have any,
investigating officer.
You said,
and
does he
he's
have any opinion, you said?
the objection.
Any objection?
To the action that was taken to dismiss Mr. Renner. Because again, he's the one that signed the affidavit. He's the one that's saying he believes this is true.
Well,
But yet he was, I just want to find out, was he okay with Mr. Renner his charges being dismissed?
yeah, I don't know how that's relevant.
Well, because it's relevant as to the other electors, Judge. As evidence comes in and we find that there's other electors with the same interest, same mindset, same everything, it goes to credibility, it goes to state of mind of everybody who was in that room, all the things we've already talked about. And so I'd like to know. I think that goes to his credibility.
This witness has testified he has no authority over the decision to enter into agreements. So his opinion on whether or not he agrees with the agreements that are or are not entered into is not relevant.
Yeah, it is. I never said he had the authority. I said, he's the one that signed this affidavit, which is the basis for the whole reason we're here today. And he said he believes our clients to be guilty. And so now I'm simply asking, well, he must not believe that about Mr. Renner anymore, or did he? I'm just trying to find out what his mindset.
Well, I think if you phrase the question that way, it's a different
Yeah.
question, and then based on the information that he now knows, that's a different question.
Oh, okay. Well, I'll phrase it that way. Thank you.
Okay.
So, Agent Shock, so based on what you know now and the evidence you have from both Mr. Renner and Ms. Ruck, did you have any objection to Mr. Renner?
No, that's not a different question. Different question would be, I was thinking, would he still authorize or swear to
I'll ask.
affidavit to authorize charges for
Thank you.
Mr. Renner?
So I'll ask it that way. Agent Shock, knowing what you know now from Mr. Renner, okay, would you have written an affidavit authorizing criminal charges to be filed against Mr. Renner?
No, knowing what I know.
Okay, so then if you had to do it today, knowing what you know about Ms. Rook, would you authorize charges against Ms. Rook today?
Found inconsistencies in her statement. So I swore to the affidavit, believe the affidavit to be true and accurate.
Well, what inconsistencies? You just said she was consistent with Mr. Renner, that there was
No,
an
no, no.
alternate slate and those things. So what are you talking about?
Specifically, I'd have to go back. I just recall after we sat down, there was some inconsistencies about her statement. I did not find any inconsistencies with Mr. Renner's statement.
I want to know what
I'll
the
just-
inconsistencies were.
So you don't know what those inconsistencies are?
I'll bring up one. It had something to do with, based on my memory, it had something to do with after the fact. That after the fact they went to the Capitol. And there was something that took place that wasn't consistent with what she had told us.
But you don't know what that was?
There's
There's no-
objection.
It was,
Well, here's my, I guess, general objection. I think the witness is answering without the benefit of refreshing his notes. I happen to have been at that proper. My client didn't go to the Capitol. She left, had lunch with a friend. She didn't do anything after she saw
What
it.
is
So
this?
I don't know what he's talking
What's
about. Maybe
happening
he's confused. Does he need objection, the witness has no foundation to answer the question without reviewing his notes. That's my,
Okay,
Yeah, maybe,
my objection.
I don't
maybe what we
believe.
could do, if Mr. Bellata's gonna recall the witness anyway, maybe I should just
Yeah.
leave that issue for him to
that's probably best.
delve into. I was just trying to get a general idea of. yeah,
That's probably best, because I thought he's originally stated he didn't recall, and he would have to refresh his recollection. So I don't know if that last answer was him guessing. Was that? is
That was my best of my recollection,
best
Your Honor.
recollection,
So
okay.
it had something to do with after the meeting at the Capitol or after she left, but I want to be,
So
you know,
something to that
accurate.
effect, something surrounding that was what you found to be
Yeah.
inconsistent.
I would have to review her
Okay.
interview again and then look at some of it.
Okay, well,
I'm
we'll
happy
have
to move
Mr.
on.
Bellata address it, because I would like to know what the inconsistency was.
And Your Honor, I would ask that he go back and look at that prior to Monday.
So, sounds good.
No, not Monday, today.
No, I don't know. Don't you have witnesses here?
I do have other witnesses here.
So, no, they may need to go today, and he can finish up on Monday.
It's not
They
my
were gonna
turn yet.
recall him anyway.
I'm just following procedure.
We might be here all day with this witness.
I'm gonna need y'all to be a little bit more positive about this.
We're trying to be realists.
I don't wanna be realistic.
It's 11:08. There's gotta be a lunch break. And there's still more questions. You know, Mr. Bellata is not the only one that sometimes takes the scenic route. Mr. Freeman might take the scenic route. And so
I take that as a compliment. I'm just gonna say that for the record.
he's from New York, so it happens. So, you know, we have to be honest about the fact that you have, is it 2 more witnesses that are waiting?
I have one here,
Oh,
one
okay.
on call.
Oh, okay, got it.
Because I wasn't sure.
Should we need to pause this?
Yeah,
That's beneficial to your witness, because he has a couple of things that he needs to refresh his recollection on.
And
Counsel?
I
I'm
just
fine
want to
with
be
that,
clear,
Judge.
I've only lived in New York for 7 years. I've been in Michigan since 2000. So I'm a Michigander at this point.
7 years is a lot of years to be in New York.
There's some truth. to that. It's like in dog years.
It's a lot of years. Okay, let's see.
I'm happy to interrupt now. I mean, I've got
You're happy
a few
to
more
pop-
counts to go through, but I'm happy to do it if it helps.
Well, do you want him to finish his line of questioning before we call the next one? That's what I was thinking would be best.
Your Honor, if I just made as a point of scheduling, we're gonna interrupt Shock again
No,
for.
Well,
another-
she has a witness here waiting
Well,
today.
my understanding was that those witnesses weren't here today, not because there was some sort of scheduling issue with those witnesses, but rather in case we got done with Shock.
Well,
I don't necessarily understand why we would now start taking witnesses out of order. I understand that we took Mr. Renner out of order yesterday at Mr. Bellata's request because Mr. Renner had a vacation coming up.
Well, you were gonna say something about the captain, somebody.
Captain Green actually works in Marquette, which is
I'm sorry, I didn't
6
hear
hours
that.
away.
Captain Green, her witness is here from Marquette.
Well, he's a law enforcement officer. I mean, frankly, who cares where he works? I mean, whether he's down here in Lansing or up in Marquette, he's still getting paid. He's a cop. So he's not going on vacation.
Well, we do care about use of public resources. We don't want to spend, the taxpayers gotta pay every time he drives down
Oh, Your
here.
Honor, I don't think we want to talk about the use of public resources in connection with this prosecution.
I can't, I have no control over what the AG's use of resources are, but I do have control over what uses come out of this courtroom. And so to the extent that I'm gonna order someone to drive back to Marquette, because today's Friday, or get a hotel for 2 days to come back on Monday, and I don't know how long his question is gonna be, but if I'm gauging it based off the last time, it's not long.
Well, Your
It's
Honor,
a-
what that potentially does is because I'm last in the batting order, what you're potentially talking about is me not getting to this witness. I've been waiting for 3 days to question.
No, you will get to the witness. You mean you won't get to him today?
That's my concern.
Well, you wanted to wait anyways because you wanted a transcript.
Your Honor, that was, at the beginning.
You wanted to wait.
That was at the
We might
beginning-
have a transcript by
that was
tomorrow.
at the beginning of this proceeding.
I get that.
Okay, my only agreement was to interject.
There was no
for
agreement.
For Mr. Bowada's request for Mr. Renner to get Mr. Renner on, because Mr. Renner was going to be unavailable due to vacation. I have a strong objection that we're gonna do anything to accommodate Captain Green. I am mindful that there are resources at play here. However, he is a law enforcement officer. He's assigned to this case. It's the people's scheduling. The people are not the ones that are asking to insert Captain Green in the middle of a cross-examination of the key investigator in this case. If that request is coming from the people, it's not appropriate at this point. I think we proceed with this witness. We go all day with this witness. We get as far as we can, and we see where we are.
I'm glad that you have a position about how I'm gonna run my courtroom. We're gonna run it the way I wanna run it.
I understand.
So
Honor,
your
but the
objection
rules-
is noted.
the Rules of due process
Thank
still
you.
apply.
They absolutely do, and I get to run. Even if I felt like I have enough now to move on, I can cut this off. This is a preliminary examination. It's not a trial.
Gilbert from Mr. Thompson. I understand the court's position on it. I recognize it. It's very logical. However, in a continuous interruption of a witness to accommodate other witnesses without having what I would consider, which would be different than you, a legitimate reason to appear immediately. It's a scheduling issue. You're in control of your docket. I fully understand that. However, the prosecutor is in control of who she presents and the order she presents them.
I completely agree. That she didn't make a request.
I didn't.
She didn't make a request for this. This was my suggestion.
Oh,
Because we're still not finished with him, and there's still, I need to refresh my recollection. He's going to be recalled anyways. We established that already, that he's going to be recalled.
correct.
So we could stop now. He's gonna be recalled regardless.
Correct. But it's the interruptions between. That's my.
The
point.
interruptions between
I just would-
are doing what? Because you've had your cross-examination
Part of it.
and you requested to recall him.
Right, and that was because it was at the end of the day.
But you didn't, but not just in the day, you passed over to the next examination. So you really are not in a position to even make, I can understand him having a concern. He hasn't had his bite at the apple yet. You've had a bite and passed over with the understanding that you would recall him at a later time. When that later time is going to be is not up to you.
I would agree with that. As a given that rationale, I'm still wanting to make my position known, but I better understand the court's position.
Thank you.
Thank you.
You can continue with your question.
Thank you, Judge. All right, Agent Shack.
Yes, sir.
After all that, we ended before the break. You stated that you had no evidence that Hank Choate knew that he had knowledge that the instrument falls on the porch. Correct.
No direct evidence,
Right.
plenty of circumstantial evidence
What's the circumstantial?
that the document was what, altered
No,
or
no. That
What?
Hank Choate knew that the document was uttered and published that as being false, altered, forged, counterfeit.
so it's,
That Hank Choate knew that.
it starts with the popular vote. So President Biden had won the popular vote. The votes had been certified on November 23rd. The Democratic electors had been called to the state capitol building, and again, the circumstantial evidence would be that, you know, Mr. Choate was following this information. Mr. Choate chose to go to the Michigan GOP headquarters, sign a document, walk to the Capitol, you know, with trying to assert that this is the legitimate doctor, or this is the Republican slate of electors, when the legitimate slate of electors had already convened.
You said something interesting there. That Mr. Choate knew they were the Republican slate of electors. That's right. That's what he knew, right?
I don't believe the witness said that. That's a
exactly what he just
mischaracterization
said.
of
Is
his
an
testimony.
objection?
Yes, it's a mischaracterization of his testimony.
If you
Well,
want to
that's what we
respond.
Clarify, because he said Mr. Choate walked to the Capitol, knew he was an alternate, the Republican slate for the, and then he went on and said something else.
Was your
after that.
question to,
So my question was, so Mr. Choate knew that he was the Republican slate for the electors, right?
he's trying to, well, look, we're addressing an objection right now. So the objection,
That's not the question I objected to.
what was the object?
The question I objected to was that he was, counsel was saying that the witness testified that Mr. Choate knew he was an alternate Republican elector, which was based on the witness's previous summary, and I was saying that was a mischaracterization
Of the
of that
witness's
testimony.
testimony. Oh, as to that, the objection sustained.
Well,
You can continue with your question.
Okay, I think he answered the question that Mr. Choate knew he was a Republican slate. On the Republican slate
He
for
stated
electors.
that.
And you said yes, right? Okay, now, those are all, you listed 6 things here, circumstantial evidence that prove Mr. Choate's knowledge that he uttered and published as true a false, forged, altered, counterfeit record. Okay, here are the 6 things you said. I want to ask you some specific questions. You first thing you said was, well, there's a popular vote. So by that you mean President Biden by the popular vote had 2.8 million, whatever, and Mr. Trump had 2.65, whatever million votes. Is that what you mean?
Yes, sir.
Okay. How does that piece of information prove Hank Choate knew he was uttering and publishing a false, forged, altered, or counterfeit record?
He signed the 2020 certificate of vote.
Okay, and here we are going in circles again. He never saw the first page, right? You have no evidence of that.
No direct evidence, but circumstantial evidence.
You have no evidence that Hank Choate saw that first page, do
You
you?
just answered that question.
Well, what's the circumstantial evidence that he saw the first page? This is the first time I'm hearing this. Did you have a chance to talk to the AG when we were on break or something? Are you changing your testimony?
That he stated that, we're gonna strike that. He stated that yesterday, that there was circumstantial evidence under another cross-examination.
Okay. Well, what's the evidence? What's the circumstantial evidence that Hank Choate, by signing a signature page, okay, with nothing else with it, means he knew he was uttering and publishing a false document or forging a false document?
Well, along with Mr. Renner's testimony, others had said that there was multiple documents along with the signature page.
But he said he had no personal knowledge that Hank Choate saw those documents, and he never saw Hank Choate sign documents. So he didn't testify Hank Choate saw any of those documents.
He being Mr. Renner, correct?
Mr. Renner, yes.
Yeah. Yes, that's why I said there was no direct evidence versus
Well,
circumstantial evidence.
How is that circumstantial when Mr. Renner said I didn't see it? And that he didn't. He had no evidence at all.
As I mentioned, there was other people there that saw that there was multiple documents there that would coincide.
And where's the evidence for that? Who
Your Honor, I
testified to that?
asked that the witness be allowed to complete his answer before the next question.
You can complete your answer.
I believe that there's going to be a couple of more witnesses called that had shared that information.
But as we stand right now, you don't have that information, right? And it's not before the court in this proceeding, right?
No. It's in the reports that I interviewed those witnesses.
And again, none of those reports indicate or state that Hank Choate saw the first page, do they? Did you already testify that he-
Yes, I don't have any direct evidence that he saw the first.
So again, this is your assumption. This is your guess that, well, because documents were floating around the room, maybe he saw it. Is that what I'm gathering from your testimony?
I would object to that characterization that documents were floating around the room. I don't believe the testimony for that.
Cross-examination, I can characterize things. he's saying that there were other documents in the room. I would not, the document that I've heard of so far is the one Mr. Renner.
The objection is to the terminology of floating around the room.
Yes.
I'll take that out.
Thank you.
Thank you.
So, again, sir, you have no even circumstantial evidence that Mr. Cho actually saw the first page of that document. Do you?
Circumstantial evidence. I have no direct evidence to show that he specifically saw it. I have circumstantial evidence to show that there was other documents there, as Mr. Renner indicated, and others have indicated.
And so the second thing you mentioned, the circumstantial evidence. Well, let me ask this. Back to the popular vote. Do you have any evidence of Hank Cho about the popular vote other than the certificate of vote, second page of exhibit 11?
I have circumstantial evidence that shows that Mr. Cho was following, whether it was media reports, following what was going on at that time, whether court cases, things like that, through the social media.
And how do you know that?
Social media return.
Okay. So were there social media returns that were actually talking about the votes for President Biden versus Mr. Trump?
There was, yes.
Okay. And you believe that the mere fact that Mr. Cho may have known that President Biden got 2.8 million votes, that's evidence that he knew he was uttering and publishing a false, fake, forged document.
That Mr. Biden had 2.8, that yes, that Mr. Trump had 2.6.
Okay. And then the next thing you said was the Democrat electors had been called to the Capitol. How was Mr. Cho supposed to know that?
I don't
I'm gonna
know.
ask for clarification. I believe we are talking about the Lansing Capitol, but we've had a couple different issues with that as being the annex, the Capitol building. That is important to me as far as this question goes.
Well, I'm saying because he said Capitol building. I was just repeating what he said.
Very
So-
good.
Can we clarify?
Yes, the state capitol.
So again, my question is, how would the fact that the Democrat electors were called to the Capitol have any bearing on Mr. Cho's admitting, uttering, and publishing?
Because they were there in official capacity.
Okay,
They
did Mr. Cho know that?
that the Democratic, yes,
How do you know that?
because they were told that at the Capitol when they went to the Capitol.
Okay, so he didn't know it when he signed. You didn't know it when you claim he uttered and published the document. That's after the fact. How do you know that he knew when he signed his name on that one page signature page that the Democrat electors were meeting at the state capitol?
Because it's also known that by law that that's where they're supposed to meet at that specific time. Mr. Cho was contacted or appeared at the Michigan GOP headquarters at that particular time just before. So
Okay. Now, how is that relevant to whether or not Mr. Cho knowingly uttered and published a fake, false, or forged public document? The fact that the Democrats are meeting at the state capitol, how does that matter to his knowledge and what he knew about uttering and publishing?
because that's the legitimate electors, and these weren't the legitimate electors.
In your opinion, right?
Move to strike.
No, that's a question. In
Oh,
your opinion.
No.
This question? Okay.
Yeah, it is, in your
That's a
opinion,
valid
the
question.
Democrat that were the legitimate electors, right?
Yes, based on the review of the documents that were signed off by the state of Michigan.
Do you have any direct or circumstantial evidence that Mr. Cho actually saw the official certificate of ascertainment from the Democrats?
No,
Do you have any information that Mr. Choate, direct or circumstantial evidence, that Mr. Choate saw the official certificate of votes from the Democrat electors? And I asked these two questions prior to him signing. That he saw the certificate of ascertainment or that he saw the certificate of votes from the Democrats?
no, sir.
Said the next thing, circumstantial evidence. Mr. Choate chose to go with the Republican headquarters. Do you call that?
Yeah.
Okay. How does that prove he knew he was uttering and publishing a false public record? Forged.
Just by going there?
Is that a yes?
No,
So I asked how, and you said just because he went. So because he was at the meeting.
I was asking for clarification, just,
Right, and
Oh,
I thought you
going-
said,
I thought that
mhm.
was your answer.
no, just by going there, I was asking for clarification.
Well, that's what you said. Mr. Choate chose to go to the
Yeah,
headquarters to the meeting. So his simply going to the meeting proves he meant to knowingly utter and publish a false, forged, altered, or counterfeit record.
Yeah, and I'm gonna object, that's a mischaracterization when the witness was eliciting, well, within his answer of the circumstantial evidence, he laid out several bullet points. This counsel is isolating each one and saying just this bullet point, just this bullet point. That's a mischaracterization of the witness's original answer.
Your Honor, I would actually join and basically say this, when it comes to the witness, he can say whether or not it's a mischaracterization. Counsel here is stating it's a mischaracterization and frankly, putting almost testimony in his mouth that he can use.
Well, again, Your Honor, I can't question him on the 6 points that he
Yeah,
raised the circumstantial evidence. I
he
have to
did
do it as a group.
Give a list of what those things he believed called or caused there to be circumstantial evidence as to why he would have or should have would be guilty of these actions. I think that he can go through those lists and ask specifically, what about this would cause him? Because it may not be that it's an individual, that individually won't be that. That could have been his answer.
Well, yeah.
But he has to be allowed to answer, just like you keep asking allowed to answer. You can't keep telling him it's a mischaracterization. He knows what he should know. What's a mischaracterization of his statement? No, I didn't say that. That's not what I was saying. He should be able to say that.
That's.
A mischaracterization of his statements, he should be able to identify that.
What I'm saying is the question was a mischaracterization, and I'm allowed to object when he's mischaracterizing evidence that's on the record.
His question took one element of what his response was and now asks him, how was that? How does that go towards the evidence? He can do that.
But he framed the question to the exclusion of all of the bullet points, which is not what the answer was. It mischaracterized.
Because he's trying to figure out how each played into the totality of the investigation.
I'm not sure I understand what the objection is.
That you only took one bullet point
But that's not
of
an
the
objection.
list
She
of
just
what
doesn't
he.
like the way.
No, the objection is it mischaracterizes his statements.
But I guess-
He could easily say, I didn't look at that just by itself,
He could.
but you didn't give him an opportunity to respond.
That is possible. I didn't give him an opportunity, but I am allowed to.
He could say, well, that by itself means or will cause me to believe X, Y, and Z. We don't know. He can go through those bullet points individually, just like we go through the elements individually to see how we got to the whole. He can do that. That's not mischaracterizing his testimony because he provided that as one of the bullet points as to how he got to the circumstantial evidence. So he's trying to now break it down, and that's what he's here. That's what the evidentiary hearing is for, to break it down. Yes.
My objection is not to asking about each individual bullet point. My objection is the mischaracterization that isolating one bullet point is the only circumstantial evidence for uttering and publishing.
I don't think that's what he's for asking him, if that was the only.
I never asked that.
He didn't ask them if that was the only. We already have his answer, which is that these are all the things that cause him to have circumstantial evidence. So now, well, let's take the first thing. How is that evidence? And so he can break that down. If that doesn't change his other statement, that all of these things is what brought him to circumstantial
Well,
evidence.
if I remember the question that I objected to, and it's been a minute, I believe the question was something to the effect of, so going to the Michigan Republican headquarters alone is circumstantial evidence that my client committed uttering and publishing. And I'm saying that that was a mischaracterization of the witness's private answer.
But he didn't say that. He can ask that question even if your client didn't give those bullet points. He can say going along, or your witness, that is, didn't give a bullet list listing that. He can still ask that question. That doesn't mean it's mischaracterizing his statement. It's going to the Capitol alone evidence of guilt or intent. And that's been used multiple times as one of the reasons that brought us here, that they took it to the Capitol. So he can ask the question and isolate that to see if his understanding is that alone would have caused this to be. Maybe it's a yes, maybe it's a no, but he has to be, that doesn't mischaracterize his testimony about how he got to his circumstantial evidence. He's just breaking it down. Thank you. So the objection is overruled.
My question.
Because going to the Capitol alone, if that's.
Yeah, I think I'd already talked about the Democratic electors at the Capitol. So the next one I was going to was Agent Shock. You said for circumstantial evidence, the third bullet point was Mr. chose to go to the Republican headquarters. And I assume you mean on December 14th, right?
Yes, sir.
Okay. So how did Mr. Cho choosing to attend a meeting of the Republican Party or the Republican electors prove that he knowingly uttered and published as true that document?
It was a combination. It was a combination of all those things that I mentioned.
Okay, and I'm trying to ask, so how does that play into it? So he chose to go to a meeting. How does that prove he knew there was even a document that he was going to sign, or that he was agreeing to participate in a crime? How does that prove anything? He chose to go to a meeting.
But it wasn't just any meeting. It was a meeting where 16 people were called. 2 people did not show. This was on a specific day with a specific purpose. So it was all of those things. So it's not, to answer your question, it's not just a meeting. If I went to a meeting on, I don't know, May 31st, just to show up to a meeting.
Again, let me.
So to answer your question, it was a combination of those things, sir.
Yeah. So he was going to a meeting for the electors on December 14th at the Republican headquarters. How does that prove he uttered and published anything? That he chose to go to a meeting?
I think you just answered it.
He talked around about it, saying, well, it was just, I'm trying to get to the actual charge of uttering and publishing. How does it prove that? I understand he thinks they were doing things that were inappropriate.
He said they went on a specific day for a specific purpose, and it wasn't that by itself. That was his answer.
Okay, I'll move on. The next one you have, Agent Shock, is again that he signed the document, and we seem to be coming around to that. I mean, that's not circumstantial evidence. He signed the document, right? Okay. And we've been through that before on these charges. Is signing a document, if he didn't see the first page, which again, you acknowledge you have no evidence that he did. How is that uttering and publishing anything to simply sign your name on a signature line on a page that all it has is a signature, signatures of all the electors?
It's not, but when you add all the circumstantial.
That answers my question.
Okay.
It's not. All right, the next one. You said he walked. Now this is slightly different. The earlier one was the Democrat electors who were at the state capitol. This one is, you said he walked to the state capitol, right?
Yes.
Okay. That was after the fact, right? That was after the meeting at the Republican headquarters, right?
Yes,
That was after he'd signed the document, right?
yes,
Okay. The uttering and publishing, if it's to be believed, and if it happened, did that happen at the meeting? Or where did the uttering and publishing happen?
well, the part of it was at the meeting, the other part was to publish it, to serve it at the Capitol.
Okay, but it actually wasn't served, right? So it wasn't published,
It was rejected,
right?
but it was served, but it was rejected.
How could it have been served if it was rejected? That makes no sense to be served. You're an officer, you know that. Service means the person gets it and they receive it and they're served with a document. Nobody was served,
I
right?
would object to that not being a question.
It was a route.
Nobody was served, right?
Okay, the justice is saying he rephrased the question.
At the Capitol building that day on the 14th, nobody at the Capitol building was served with any documents, were they?
Yes, the trooper,
So the state trooper received the documents and he got served?
I didn't say that he received them. I said he
Well-
rejected, he served.
Agent shock. I mean, how you, I don't know what service means of documents?
Telling you what I believe to be true. So he was served, he decided to reject the document. That's it.
Okay. But you don't know what he was supposedly served with. I mean, nobody got served. And you did he keep that, whatever was in the
I would move to
envelope
strike
Mr.
that.
Northman had? I'm phrasing a new question.
Okay.
Whatever was in that envelope that Mr. Northman had, did the police officer take it and accept it?
No, sir.
Okay. So nothing was filed or given to the state that they took inside from that meeting at the state capitol that afternoon, correct?
They didn't take anything inside that I saw.
Right. Okay. So they did not get the paperwork, right? Whatever was in that envelope, and we all already established, nobody knows for sure what was in it. Whatever was in it, the state never got it, right?
Could you be more specific? Are you referring to the state trooper or the state of Michigan?
Anybody at the Capitol building that day,
Okay,
they received nothing from this group that walked to the Capitol building, right?
it was rejected.
That's right. So
Yeah.
they received nothing, right? They didn't get any paperwork. Right?
Now, yes, if that's.
Okay. So I think yesterday when you were being questioned on this by somebody else, you said it was published because it got mailed to the National Archives and to the House, or not the House, the Senate President's office, right?
The US Senate.
The US Senate.
Yes, sir.
Okay. So is that where you think the publication occurred? That's how it was published?
Yes, that's the publishing.
Okay.
of it.
What evidence do you have that Hank Choate sent that, mailed that to the National Archives or the US Senate?
I don't have any direct evidence to show that he
Well,
mailed it.
You have direct evidence that somebody else mailed it, right? Why are you parsing this so much, sir? Why can't you just admit?
Are you gonna let him answer the question?
Yes,
It was Ms. Bearden that sent it, right?
no, sir.
Well, who sent it?
I had circumstantial evidence to show that Mr. Flynn
Okay,
sent it.
so you know my client did not publish it to the US Senate or to the National Archives, right? You know that,
It was published there.
not by Mr. Choate,
Your
right?
Honor, the witness was still in the midst of his answer.
Mr. Choate did not publish it at the Senate in the archives. I'm sorry.
Thank you. Did Mr. Choate publish that certificate of vote of the electors, 2020, the Republican electors, that document? Do you have any evidence that he published it anywhere?
No.
Okay. Thank you. The last thing you said for circumstantial evidence was that Mr. Choate knew he was a Republican. Do I take that to infer meaning he knew he wasn't the Democrat slate? Is that what you meant by that? Can you explain what you meant by
Yeah, I don't have any information to suggest that he knew that he was the Democratic. Like,
that? Right. And he did not try to fool anybody or trick anybody to thinking that he was part of the Democratic slate, did he?
no,
So again, how is that evidence that he uttered and published as true a false, forged, altered, or counterfeit record, the certificate of votes? How does that fact prove he uttered and published?
so again, we go back to the popular vote. Joe Biden had won the majority of the vote.
No, I'm not asking you to repeat all of your bullet points,
I
sir.
don't,
I asked you this one specifically, where he said, I'm the Republican elector. That's a Republican slate. And I'm asking you that bullet point, the last one. How does that prove he uttered and published a
By-
false?
by signing the document and the document being published.
Sir, can you please answer my question?
I'm doing my
We
best,
talked
Mr.
about the
Tallman.
signed one, that we talked about that. I'm talking about the mere fact that you said it's circumstantial evidence that Mr. Cho represented himself to be a Republican elector and part of the Republican slate. That is circumstantial evidence that he uttered and published. I'm asking you, don't talk, I don't care. We talked about signing it. We talked about all the other stuff. How did that fact provide you any evidence, let alone circumstantial, that meant that proves he uttered and published?
I'm going to give you the same answers, and I know you're getting frustrated with me. I don't have any other answers for you, sir. So he claimed to be a Republican elector. He had signed the document. He walked with the party to the Capitol, and I'm not trying to be disrespectful, Mr. Coleman, but I don't have any other answers for you.
Okay. And you just said an interesting thing. He claimed to be a Republican elector. He is a Republican elector from back in 2020, right? He is a Republican elector.
Yeah.
Okay.
That's what
Why do you
just
use
said.
terminology? Well, he claimed to be a Republican elector. He was a Republican elector, right?
And that's what he claimed to be. He claimed to be it in Mr. Monger's, I believe it was Mr. Craig Monger's news article.
Okay.
So that's why when I say claimed, it's
Well,
something, I'm not trying to infer anything else.
well, that's what, why do you say claimed? Why don't you just say he is a Republican elector?
Because that's what he claimed to be in the article that I read.
Well, was he a Republican elector?
Yes. I mean,
There's no question.
All right. If you look at count 4, and again, I don't want to belabor the whole thing, I'll just ask you if your answers would be the same. The conspiracy to commit, uttering, and publishing. And again, we have the words here, he had to unlawfully conspire. Is it your position, you say Myra Rodriguez, Sean Maddox, and other persons? Are you again referring to the 15 electors?
yeah,
Okay, nobody else, right?
no,
Okay. And again, we went through the questions before on conspiring, combining, confederating, and agreeing together. I just want to make sure. For the uttering and publishing, how did my client conspire, confederate, combine, agree to commit with the other electors, the other 15, to commit the crime of uttering and publishing?
by signing the document with the others and meeting together.
That's what you said earlier on the first count 1. So it's the signing of the document and the meeting. Those were the 2 things you said earlier too. Okay. So would your answer to all my questions regarding conspiracy earlier this morning be the same? As to,
Yes.
that you wouldn't change your testimony on any of that?
No.
Okay, I'm not gonna waste our time with it.
Okay. I don't have anything else to offer. Mr.
Okay,
Coleman.
thank you. All right, let's look at the last. Hang on just 1 second. And again, just so we're clear, stuttering and publishing, nobody forged Governor Whitmer's signature on the document. Question part about the 2020 vote certificate, right?
Which 2020 votes?
The Republican one.
Oh, no,
Exhibit 11,
No.
pages 2.
Yeah, okay.
Okay, yeah, right, I should be specific.
Yeah.
So nobody forged Governor Whitmer's signature, right?
No.
That's correct. I mean,
Oh, yes, yes, it's correct.
quarterly asked, thank you.
Yeah, okay.
And there's no seal of the state of Michigan on that document, the same document, right?
No, sir.
And that document never claimed to be the legally required election certification or to have that certification from the governor, right? Never said anything like that. Is that correct?
No, I did not see any gubernatorial certification on it.
Okay. All right, I'd like to move to the last 3 elements or counts, honey. These are generally under election law forgery. And you see those, you still have the complaint?
Yes, sir, I do.
Okay, thank you. And going to count 7 and 8, it says election law forgery. You see that?
Yes.
Okay. And here again, it's being alleged, again, I don't want you, I mean, obviously the AG,
I understand
Yeah,
this,
the
Paul, man,
AG's
there's no
office
offense
is-
taken.
yeah, it is claiming or alleging that Hank Choate knowingly make, file, or otherwise publish a false document with the intent to defraud contrary to the cited statute, right?
Yes, yes,
Okay.
that's what it says.
And that's counts 7 and 8 say the same thing, right?
Yes.
And I'll ask the same question. I know I asked it for counts 2 and 3. There's only one document here, right?
Yes, but there was 2 that were published.
But there's one document. There's not 2 separate documents. There's not 10
Oh,
documents. There's one
yes,
document.
yes,
right?
you're right, sir. Yeah.
Okay, so I'm not asking what was published. It
I
could have
get-
been published 10,000 times. I don't care.
I misunderstood your question.
No problem. So there's one document that we're talking about
Yeah.
here. And there, can you explain to me why there's 2 counts?
Because it was published twice, it was sent, same thing when I said with forgery, I mean, it was sent to the Senate and it was sent to the archive.
Okay. And you say it's under election law forgery, right? That's the heading on this count. 7 and
Yes,
8.
Oh, okay, I didn't know you were asking me a question.
Okay. So again, the same question knowingly. How did Hank Choate knowingly violate the election law by committing a forgery?
Because it wasn't the legitimate certificate of vote.
So again, I won't go through all the same questions. Would your answers be the same then? That
Yes, sir.
Forged, the
Yes.
difference between the fake and false and forged, all of your answers from earlier would be the same.
Yes.
Okay. Can you explain to me why there are, well, are there other, for lack of a better phrase, unindicted co-conspirators who also committed election law forgery or other illegal functioning? Are there others that are not part of the elector group that are being prosecuted?
That are being prosecuted?
That are not being prosecuted? That they're not part of this group?
It's still an open investigation. As far as you're asking me, if they've been charged. There's nobody else that I'm aware of that's been charged. With that said, still an open and active investigation.
So when we're talking about the conspiracy charges here, it's really not just the 15 remaining electors, is it? There are other people that you believe those electors conspired with, right?
Yeah.
Okay. Who are those other people?
Well, we've talked about Sean Flynn.
Mhm.
That would be one of them. We've talked about Mr. Chesbro. Okay, so that's all that I can recall.
Then let me ask this, for these other people who are not part of the electors group that are involved in this process, for these other people like Mr. Flynn, Mr. Chesbro, whoever, what evidence do you have that Mr. Choate ever contacted them, talked to them, had any interaction with them at all?
Well, as it's been mentioned already, that Sean Flynn was in the basement at the time, so he was talking to the group.
Right,
Mr.
and that's fair. I mean,
Okay.
individually.
Oh,
Was
no,
there
I,
a
nothing.
specific interaction between Hank Choate
Okay,
and Mr.
direct,
Flynn? Yeah, direct.
none.
Okay. Either before or after December 14th? As far as you know.
Yeah, yes, that's,
Okay. And the same for Mr. Chesbro. Was there any direct contact between Mr. Choate and Mr. Chesbro?
no, I did not find it.
Okay. And again, here on this, I don't want to just repeat all the same questions. I'm assuming when we talk about the issue of knowing, you know, Mr. Choate knowingly, would your answers be the same?
Yes,
as
yes,
before?
sir.
Okay.
Thank you.
Nothing different than what we've
No,
already
no,
done.
sir.
Okay. And then the same thing with then count 6 on the conspiracy to commit the election law forgery. Again, issues like the word unlawfully, knowingly, would all your answers be the same?
Yes,
With the people? And
yes, sir.
everything, okay. So no difference in your answers to those questions. Is that correct?
Yes, that's correct, sir.
Now, you had mentioned that one of the reasons why in your affidavit, you believe that the electors at that meeting knew what they were doing was criminal or improper was because of that one lawsuit that the federal court had ruled out. I don't remember the name of the case, but a week before the meeting, there was a federal decision to say that a challenge to the election results had been thrown out, right? You talked about that.
Yeah, I remember talking about a suit, yeah.
Okay. And I know we talked about there were other cases pending at the same time. I don't need to rehash all that. But my question here is, what evidence do you have that Hank Choate or any of the electors knew on December 14th at that meeting about that decision 7 days earlier in the case you cited?
That they knew about that decision?
Right. You said there's a decision December 7th where a federal district court judge had thrown out a lawsuit challenging the election results. And that because of that, you claimed in your affidavit that all the electors knew that they had no legal basis to move ahead with what they were doing. So my question is, how did they, what evidence do you have that they knew that on December 14th?
There was no direct, but I had circumstantial evidence to show that they were following the media reports. They were, talking about court cases and things like that.
Okay. And there were multiple court cases, right?
Yes, sir.
Okay. Would you agree that Mr. Choate, Mr. Renner, Ms. Rook, and the other electors accepted the direction and advice they were given by the leaders of the meeting that day on December 14th?
When you say they accepted the advice?
The advice and direction.
Yes, that
Yeah.
they signed off on the
Yeah.
signed off on the document,
Because
yes.
people leading the meeting put that, lay this thing out, you're an alternate slate, all stuff Mr. Renner said. And so the people at that meeting were following the directives that they were given at that.
Yes, but I don't have any direct information to know what he was thinking at the time.
No, but your answer is yes, he was following the direction that was given to them. I'm not asking. I'm not asking for.
All I know is
so
he signed the document, sir.
Okay.
Sorry, Your
Did
Honor.
Mr.
Can we get an answer? It's unclear to me. Is he saying that he agrees that the electors were following the directions? Or is he not agreeing? Did we never-
But he said he doesn't know. He just know that they signed the document.
that he knows they were following the directions?
He doesn't know.
Okay, thank you.
That's what-
Yeah, I'm sorry. Is it?
That's what
Yeah.
they said.
Agent Shock, do you have any information or do you have any evidence that Hank Choate received a pecuniary gain or financial profit from his signature on that page? On the certificate?
No.
Did Mr. Choate receive any financial benefit by being a Republican elected from the information in your investigation?
I don't have any information.
Yeah, in other words, you didn't get the evidence that he got paid. to
Oh,
come
no,
to
that's your question.
Or
Okay,
that he
no,
received money or
no,
any kind of financial gain, right?
I had to clarify your question, but
No
yes.
problem, okay. Do you have any evidence in your investigation that Hank Choate received any financial gain because somebody else submitted documents? And you believe Sean Flynn to the federal government,
He received any money?
that Hank
No.
Choate received any financial gain because
No.
that happened? The answer is no. Okay. Do you have any evidence that Hank Choate, anything that he did in this proceeding, tricked or deceived another person out of any money?
No, I thought you were gonna continue.
No,
I'm sorry.
I'm gonna go with a list.
Okay,
I
okay.
know I kind of ended it.
Yeah,
there, sorry. So no money, anything that Hank Choate did, trick or deceive anybody out of real property?
Anything that he did?
Yeah. Did it trick or deceive anybody out of real property, real estate?
Okay, no real estate.
Okay. Did anything Hank Choate did in that day or at any other time, trick or deceive anybody out of anything of financial value? Financial, not.
I'm just trying to think of
Yeah, take your time.
ways
Think about
that,
it. I mean, I'm not aware of any. I'm just trying to find out if you.
Like-
think you
Multi
found something.
strike, stricken.
Okay,
can't recall what the lawsuit says, so they may have made claims of that. I just don't recall that. And when I say lawsuit, I'm talking about the civil lawsuit.
Right. But you don't have any evidence to prove that anything Hank Choate did tricked or deceived anybody out of something of financial value. I'm not talking about, I know they claim in that, let me preface this. I know they claim in the civil suit that they were trying to usurp the position of the other Democrat electors and things like that. I'm not talking
Yeah.
about that.
Okay,
I'm
no,
talking about financially, money wise. Did anything Mr. Choate do trick or deceive anybody out of anything of financial value?
no money.
Okay, thank you.
Can I ask for clarification on that? Said no money. The question was financial. Okay, it kind of gives a broader spectrum.
Yeah.
I agree.
Yeah, like stocks or bonds or any kind of
Yeah.
financial value.
Any financial value?
No,
No.
Okay, thank you.
yeah, I'm sorry, that's what I meant, but
I think I probably took it that way, but thank you for the
Yeah.
clarification. Thank you. Did anything Hank Choate did in this process trick or deceive or fool a government official?
no.
Thank you. And I know it sounds probably kind of silly, but you weren't present on December 14th at the Republican meeting, were you?
No,
I
sir.
know you weren't even on the case, but I
No,
just need to ask. And so therefore you didn't witness any of the signatures yourself directly, right?
no, sir.
Okay. One moment. You're on that moment. You may have been asked this, Aiden Shock, but were you familiar with the electoral process in the state of Michigan prior to your investigation in this case?
I just knew that the popular vote was, whatever candidate received the popular vote, then the electors would move forward and cast their votes for the president.
Exactly. I think we all kind of, everybody in the general public, at least we hope would understand that.
Yes,
But did you have specific understanding, anything about the process and how did electors go about doing their voting? Did you know anything about that before you started your investigation?
No.
Did your investigation show that Hank Cho understood any of those things before he showed up on December 14th?
My investigation showed that he had political experience. I would
That's not
have
my
to.
question, sir.
What's
Do
your
you have
question?
anything to show? You said you didn't have specific knowledge about the process of the electors and how they vote.
Yeah.
You didn't know. I'm asking you, do you have any evidence that Hank Cho knew that? Not in general about stuff. I'm talking about, did Hank Cho know what the process was when he showed up at that meeting on December 14th?
I don't know if he did.
One moment, Your Honor.
No problem.
Your investigation showed that, well, let me ask this. You did a search warrant for Mr. Cho, right? Like you did for some of the others, like you got stuff for Ms. Maddock and Benjamello and others, right? Did you do a search warrant regarding Mr. Cho?
Could you be more specific on which search warrant we're talking
Well,
about?
I don't know. If there's multiple, I
Oh,
want to know about
yeah.
all of them.
Oh, yes, social media. Yes, I thought you might be referring to something else.
I'm just talking about in general.
Okay.
All search warrants.
Yes,
So let me ask it that way. How many search warrants did you initiate involving Mr. Cho?
just on the Get Send Go account and the social media.
Okay. And for the social media accounts, did you find anything that you thought was relevant regarding Mr. Cho and what you received back?
I would have to refer to my report on that.
Mr. Cho's never been an elector before, has he? Your investigation showed that.
Not to my knowledge.
Right. This was his first time ever being an elector, right?
Again, I don't know if it was
Well,
his
as far
first
as
time,
you
but
know.
as far as I know, no.
Okay. In your review of all of the evidence, again, I know it's a lot in this case,
Yes, sir.
did you find any evidence that Hank Cho ever had any contact prior to December 14th and right up to the time of the meeting at the Republican office, that Mr. Cho ever had contact with Mr. Chesbrough?
No, that I said that.
Yeah, I'm sorry, you did ask. It's Sean Flynn. What about Rudy Giuliani?
No.
What about Mike Roman?
No.
And again, my question every time is,
Yeah,
Mr. Cho.
yeah, Mr. Cho, I follow you.
Contact, okay. Any other representative of President Trump? To your knowledge?
No.
Okay. And I think I did ask you about, well, just to be sure, I'm not sure I did. What about Michonne Maddock? Mr. Cho, did he have contact with her prior to December 14th?
I would have to look through social media stuff.
But nothing comes to your mind?
I don't recall.
Okay. What about Kathy Beard?
Again, I would
Same.
yes.
Okay. Myra Rodriguez?
Mrs. Rodriguez, I don't believe had any social media, so
Okay.
that the answer to that would be no.
And what about Ms. Sheridan?
Again, I'd have to refer back to social media.
And again, I don't think I asked this regarding Mr. Cho. I know we probably beat to death on this issue, the Shirky Chatfield release on December 14th. But as to that, do you have any evidence that Hank Choate was aware of that press release or saw that press release or statement prior to the meeting on December 14th?
I don't have any direct evidence, but I have circumstantial evidence to show that he was following media reports.
Okay,
And there was,
but
it was actually goes back to November 20th, but there was another one on the 14th as well.
But I said, I'm asking about the 14th.
Yes,
So you don't have any evidence that he was aware of that specific statement by Shirky and Chatfield on the 14th.
I'd have to go back to the social media as well, because there was certain posts, certain defendants that were upset with Shirky and Chatfield's response.
Well, was he on the, was there some kind of a email chain or something that this got sent out to, or
It wasn't
he
an
was on that?
No, it wasn't an email chain. It was, has to do with the social media posts and following that type of media.
Okay. So nothing comes to your mind right now that
I
you
don't
can
know,
point
sir.
to say that he knew about that statement, right? Prior to the meeting.
Yes.
Okay. Oh, and I meant to ask earlier on the search warrants or subpoenas. You said a couple of times, and I understand, I don't want to be pejorative here, that this is an ongoing investigation, right?
Yes, sir.
Okay. Do you have any pending or outstanding subpoenas or search warrants for Mr. Choate right
No, sir.
now? Okay. For any of the other electors right now?
No, sir.
Same question, you know, subpoena or.
Yeah,
search
I was just,
Yeah.
that's what I was processing it. Yes, no.
Okay. Do you have any pending subpoenas or search warrants that would, in your opinion, and you're the investigator, possibly provide any relevant evidence for this proceeding, for these defendants?
You. I don't
Well, maybe, let
understand.
me
what-
ask it another way.
Yeah, I was gonna say, I don't
Because I'm
understand.
assuming you probably have subpoenas and search warrants out there for other individuals right now that are not defendants in this case, right?
I'm working on,
Okay.
yes.
Would any of those search warrants or subpoenas, to your belief, would it provide any information or documentation that might be relevant to the defendants in this case? Or is it?
You're
is it
asking me,
kinda-
that's a big ask. I don't know what kind of information would come back.
Okay. Are you looking for any information in these subpoenas or search warrants regarding any of the current 15 electors on trial?
Yes.
Okay. Just not Mr. Cho?
No, I mean, I'm looking for information about the case, more facts or evidence about the
Okay.
case. So to answer your question, not specifically about your client.
Okay. And I'm assuming, and I know you, if you get information in or whatever,
Of
as
course.
this process goes on, I'm sure you would share that with us.
And it makes the investigation very difficult to continue when that is shared throughout the United States or the world for that matter. So, yes.
Okay, thank you. You know, I asked you earlier, did you have any evidence that Hank Cho mailed or published, you know, those, that certificate of vote in 2020 to anybody? And you said no.
No.
I forgot to ask you, do you have any evidence that Hank Cho knew it was being mailed to the archives in the Senate President's office?
No.
Thank you. Sorry, Your Honor. I'm just reviewing my notes.
No problem.
Yeah, I meant to ask you this earlier also, Jack, sorry.
Yes, sir. No, no trouble.
You had mentioned that there were actually two documents at one point. I just want to make sure I'm getting this right. We have the certificate of vote of the 2020 Republican electors, which is the subject of these charges, right?
Yes, sir.
And I think you had said a couple of different times there were actually two documents. Did you mean, well, tell me what you meant by that, with two documents. They could change just because it got changed, because names were changed and things like that? Or were there like two separate ones that you saw? I just want to clarify that.
So you're right. Yes, there was two documents. The names got changed. There was
Okay.
two documents that were the same. I think that's the ones you're referring to, the certificate of votes that were mailed off.
Right.
Does that answer your question?
Yeah, but I was talking more about just the document itself. So when you were talking about a second it was just that a second document, it was just that it got changed by altering names and changing who filled in and that sort of thing, right?
Can we use exhibit numbers? Because I'm starting to get confused.
I'll rephrase. So again, there was the first draft, let me put it this way, there was a first draft of this certificate of vote, right?
Yes.
Okay, then there was a second draft where it changed some of the names and the secretary, things like that, right?
Yes, sir.
Okay. No substantive changes in the second document, right?
No, well, if I'm trying to understand what you're saying, when you say substantive, I think there was a portion that removed like Senate chambers and that changed to just the capital.
Okay. Any other, so any other changes like that, or was that the only change?
That's the only one I recall.
Other than
the names, yes,
right, right.
yeah.
Okay, thank you. And just to be clear again, Mr. Cho had no involvement in the drafting of those two documents, as far as your evidence shows, right?
No.
Is that correct?
Yeah,
I know, I'm not asking it. Thank you.
that's fine. Bless you.
Bless you.
I don't believe I have any other questions.
It is 12:15. We need to have lunch. So back at 1:15. Thank you.